Delimited judgment, item number 1.
For reasons stated in the judgment, this appeal is dismissed.
May I please, your lordship. My lord, I beg to mention, my lord, two matter, my lord. One is the court number 8, item 60, my lord. Supplementary list, my lord, that be taken up on Wednesday, my lord.
Court number?
Court number 8, item 60, supply list. Motion matter.
Heard Mr. J.I. Borbhuya, learned counsel for the petitioner who prays for an adjournment. Why are you seeking adjournment?
My lord, my senior, my lord, he will be lax in another court, my
On
lord.
the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed. When do you want?
On Wednesday, my lord.
Let this matter be listed on 11th of March.
Another matter, my lord, criminal petition for admission, my lord, be listed any day next week. my lord.
Date at the
My lord, I am mentioning item 26 of court number 8, my lord. My lord, today I have some difficulty, my lord. Let this matter come up next week, my lord. Next Monday, my lord. I am appearing for the ED, my lord.
You have informed the petitioner.
Yes, my lord.
You are the petitioner.
Yes, my lord. The
Heard
enforcement
Mr.
directorate, my lord.
Heard Mr. Ardhar, learned standing counsel, enforcement directorate, who prays for an adjournment on the ground of personal difficulties. The prayer is allowed. Let this matter be listed on. When do you want it?
My lord, 16, my lord.
16th of March.
My lord.
May I please, your lordship. Lordship, I beg to mention item number 20 of cause list of court number 8, my lord. In this case, my lord, senior advocate, Mr. A.M. Bora has some personal difficulties today. So lordship may kindly take up the matter on Wednesday, 11th of
Heard Mr.
P.P. Botakur.
P.P. Botakur, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the learned senior counsel for the petitioner. The prayer is allowed. Let this matter be listed on 11th of March.
Obliged.
Maybe, Lordship, I beg to mention, I cannot take up court number 8. Lordship, due to personal difficulties and liaison on the matter fixed on 11th,
30.
30, court number 8.
Heard Mr.
Arya Ahmed.
R.A. Ahmed, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. When do you want?
11th.
Let this matter be listed on 11th of March.
May I please, your lordship, I beg to mention item number 27 of court number 8, my lord. Can this matter taken on Friday or next week, my lord, any date?
Why?
We have some difficulties, my lord.
What difficulties?
There is a partner matter in court number 2, item number 14, my lord.
Item number?
My lord, today's court number 8, item number 27.
Heard Mr. D. Bora, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed on
Friday or next week, any date, my lord?
18th of March.
Obliged.
May it please your lordship. Lordship, may I please beg to mention item 18 of court 8. 1-8.
Yes.
And may I please beg to take up the matter tomorrow or day after tomorrow?
Why?
My learned senior counsel is engaged in a personal inconvenience.
Heard Mr. What is your name?
KG Chaudhary.
Heard Mr. A.G. Chaudhary, learned counsel for the petitioner. K.G. Chaudhary, learned counsel for the petitioner, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed on 11th of March.
If you're pledged.
May I please, your lordship, I beg to mention for listing matrimonial appeal, my lord. It was filed on 26th.
Matrimonial appeal, other court mentioning.
Obliged.
May I please, Lordship?
My lord, item number 65 of court number 8. This matter was listed on Friday, Lordship, before court number 8, Lordship. And another matter from the same affair was listed before court number 14. Court number 14 matter was disposed of, Lordship, on that day. Therefore, the court number 8 directed for listing this matter before appropriate bench, that is before court number 14, along with CD, Lordship. But this matter again listed today, Lordship.
Heard Mr. M.I. Hussain, learned counsel for the petitioner, who submits that a connected matter has been disposed of by a coordinate bench of this court.
Yes.
By whose court?
By court number 14, Lordship. Honorable Justice M. Thakuria.
Within bracket, Honorable Mrs. Justice Mithali Thakuria. And he prays that this matter may be listed before the same bench. Stop. Registry to verify and list this matter before
Along with CD is also here.
appropriate bench,
Lordship, along with CD is also here. That was also direction on that day.
along with the case diary.
Lordship. Tomorrow, Lordship. I am praying for tomorrow.
Let registry to verify.
Lordship, 33 days in custody, co-accused are on less on bail, Lordship. Tomorrow, Lordship.
No, you pray before registry for tomorrow.
May I please, my lord? This is a regular bail application, my lord. May it come tomorrow.
What is the matter?
No, the murder case, my lord, 68 days in custody, my
When have you filed?
lord. On 6th, my lord.
Okay,
May it come tomorrow, my lord.
okay.
Lost, my lord.
May I please, your lordship? I beg to mention item number 44 of court number 8, your lordship. I adjournment for the day, your lordship.
Yes, what is your prayer?
Your lordship, interim may be extended. CD is not, your lordship. CD is not, has been,
Wait for your turn.
lordship.
Wait for your turn.
May I please, your lordship? I'd like to mention item number 7 of court number 8. My senior counsel could not be present due to some personal difficulties. May the item be fixed in 13, that is 13 March, that is
What
Friday.
is your name?
FL Mizo.
F.L. Mizo, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed on 13th of March.
Lordship, I beg to mention item number 17 of court 8, your lordship. Due to some personal difficulty of the senior counsel, may it be adjourned for the day, your lordship.
Heard Mr. S.
A. Mishra.
A. Mishra, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed
Any day this week, your lordship.
13th of March.
May I please, your lordship? My lord, I beg to mention item number 16 and 17, my lord. My lord, I have filed an additional affidavit, my lord. My lord, I may be allowed a requisition, my lord, to bring the record, my lord. Yes, additional affidavit on the record.
Bring the additional affidavit.
Obliged.
May it please, your lordship? I beg to mention item number 41 and 61, my lord. This leading also in this case.
Item number?
41 and 61. 41 of daily and 61 of supplementary list. Leading counsel, Mr. Dituldas is not present here, my lord. He is out of station. He has given his letter.
41 and 61. What is your name?
Bijal Talukdar.
Heard Mr. B.J. Talukdar, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed on 13th of March, 11th of March.
My please, lordship. I beg to mention, lordship, MSc appeal, lordship, in addition to the lordship.
And some other court, go through the notice.
May I please, your lordship? Lordship, I beg to mention item number 45 of court number 8. In this case, lordship, CD is not received today. Kindly pass over that.
Case diary is there.
Notice, your lordship, and they are on interim, lordship.
Interim
Heard Mr. What is your name?
D. Soikia, lordship.
D. Soikia, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who seeks some more time for production of the case diary. The prayer is allowed.
Interim.
Let this matter be listed when?
24th
on 24th of March. The interim order shall continue till next day.
May it please your lordship. Lord, item 33, my lords, of today's cause list of court number 8. Lords, I have taken the consent of the other side. Conducting counsel, Mr. Datto is, my lord, today indisposed. Maybe taken up next week. My lords.
Lord Mr.
I'm appealing for Mr. Datto. Item number 33.
I forgot your name.
A. Ganguly.
Lord Mr. A. Ganguly. Learned counsel, you are appearing for respondent or
No, I'm for the petitioner, my lords.
A. Ganguly appearing for the petitioner who seeks an adjournment on the ground of personal difficulty of the conducting leading counsel for the petitioner. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed.
Next
When?
week, can you do?
18th of March.
No, there's an interim order.
The interim order shall continue till next day.
Give it.
May it please your lordship, I beg to mention item number 68 of court number 8.
Yes, what is
Kindly
your
the matter may be adjourned for today. Senior counsel A.M. Bora has some personal difficulty.
what is your name?
M.S. Hussain.
Heard Mr. M.S. Hussain, learned counsel for the appellant, who prays for an adjournment on the ground of difficulty of the of the conducting counsel for the appellant. You have informed the other amicus.
Yes, lordship.
He submits that he has informed learned counsel for the other side regarding his prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed. 18th of March.
Lordship, on Monday, 16, if it's possible.
Not possible.
Deeply obliged.
May it please your lordship. Lordship, I beg to mention item number 65 of court number 8. Lordship, in this matter, we have filed an additional affidavit. Lordship, the same may be called for.
All the additional affidavit.
Oblige your lordship.
May please your lordship, I beg to mention item number 35 listed before court number 8. I pray for an adjournment for today, my lord.
35.
35.
What is your prayer?
My lord, I pray for an adjournment for today.
I'm for the respondent, your lordship.
Heard, Mr. What is your name?
P.D. Chaudhary.
P.D. Chaudhary, learned counsel for the petitioner, who prays for an adjournment. On what ground?
Lord, personal difficulty of.
On the ground of personal difficulty of the conducting counsel. Also, heard Miss
L. Wangsa.
L. Wangsa, learned counsel for the respondent, who does not oppose the prayer. Hence, the prayer is allowed. Let this matter be listed.
After 2 weeks, any day.
19th of March.
My please, your lordship. Lordship, I beg to mention for listing on AB, my lord, it was fixed today, my lord, today itself, but somehow it is not listed.
When you want.
Wednesday, 11th.
Okay, Wednesday.
May it please your lordship. My lord, I am referring to item number 7 of court number 8, my lord.
Yes.
My lord, I have been informed that it may be mentioned before your lordship because matter is urgent, 187 days in custody.
Yes,
And,
what do you want?
My lord, that may be taken today, my lord.
Item number?
Item number 7 of court number 8.
No, we'll take it.
My lord.
I'm taking all matters.
My lord, much of.
Adjourned, lordship. Mention was made, lordship. regarding-
Oh, it was mentioned by somebody.
Yes,
Who?
one young girl.
No, my lord. It's
You are
my-
for petitioner,
I'm for petitioner, my lord.
but somebody who mentioned?
Item number 7, court number 8. Item number 7, you
It was,
mentioned.
by mistake, I have mentioned court number 8. It was to be court number 21.
Okay, we'll take it up.
Position is clear, my lord.
Yes. You make mention before the appropriate court.
You mentioned. It would be appropriate.
May it please your lordship, I beg to mention item number 7 of court number 21. at
Court
my-
number 21, you have to mention before the court number 21. Not before this court. You make mention before the appropriate court.
It's for court number 8 only, your lordship. It's item 28. She said item 7 by mistake.
I- I- Item number?
28.
Are you sure this time?
Yes, your lordship.
What is your name?
FL Mizo.
Not Miss F.L. Miso. Yes, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Item number 28. The prayer is allowed. Let this matter be listed on 13th of March.
May it please your lordship. My lord, I beg to mention item number 52, my lord. Upon instruction, my lord, I want to withdraw this application along with the I.
Heard Mr. S.M. Abdullah P. 52 is a criminal appeal.
Lordship, it's a appeal against acquittal, lordship.
Okay. Heard Mr. S.M. Abdullah P. Learned counsel for the appellant. He submits that he has instructions from the appellant to withdraw the instant appeal along with the interlocutory application. The prayer is allowed. This appeal is dismissed on withdrawal.
Oblige, your lordship.
It is court number 8, Musonbi, item number 1.
May I please your lordship, this matter was extensively heard.
But why it is in motion column?
Somehow it is
Somehow
displayed
it
in
is-
different column.
If it is extensively heard,
No, the order sheet will speak.
yes. So let it be listed in hearing column. Today
Yes.
we can hear it or not.
And actually, the bench has taken note of all what we have argued by them.
We have already submitted the paper also
Okay, then
Yes,
let it be listed.
in the column of the bail hearing.
No,
lordship.
Before the appropriate.
Appropriate bench.
Heard Miss M. Heard Mr. Z. Kumar,
Earlier also there was an order, somehow it came up before.
learned senior counsel assisted by Mr. P.D. Chaudhary, learned counsel for the applicant. Also heard Miss M. Kumari, learned standing counsel CBI. It is submitted at bar that this matter was extensively heard by a coordinate bench of this court. However, it has been wrongly listed in motion column. A prayer is made at bar to list this matter before appropriate bench. Accordingly, registry is directed to list this matter in hearing column before the appropriate bench. When?
But on 12, madam.
On 12th of March.
Much about.
Item 2.
May it please your lordship. It's a bail hearing matter which has again been wrongly listed in the motion column. Records have come, madam. So may I pray that after the motion matters are done, madam, matter may be taken up.
Why it is listed wrongly in motion column?
Those records have also come, madam.
We'll hear the matter after taking up motion. Hearing column Matiba. We'll take it up.
Item 3.
Call for sitting.
What is the matter?
That's on triple one close to.
You have to be louder. I must hear what you are.
Under section the triple one.
What is the offense? 21, 27, capital A. Yes, Mr. Sharma.
Lordship. He was also found in possession of some ATM cards. So Lordship, let the CD come. We'll
Okay.
listen, Lordship.
Heard, Mr. What is your name? M. Rahman.
M. Rahman.
M. Rahman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Let this matter be listed on
24th.
24th of
Lordship,
March.
another matter fixed on 17th of March, DA 6 to 5 public service.
On 17th of March.
Item 4.
May it please. This matter, my lord, this petitioner, my lord, is not named in the FIR. He was arrested, my lord, in a raid on a my lord, dhaba. Actually, kindly have the forwarding report at page 18. Because I'm not named in the FIR.
We'll call for the case diary.
Lordship, the only issue is that Bapet appears and short date will be fixed because the issue here.
Mr. A. Ganguly, same order. Call for the case. List the matter on. Give a short. 24th.
Look, 24 will be too long, my lord, because the issue is here that no notice under 41 years.
Give a shorter date.
All are 2 years offenses.
20.
Can it be on 16th or 18th? What date?
18th.
18th. Lovely.
Item 5.
May it please your lordship.
Amita.
My lord, regular bail application.
America orders of similar. Yes.
May it please your lordship. My lord, regular bail application arrested on 6/1/26, NDPS section 22, FI page 13.
Section
22,
D.
NDPS.
It is pending investigation.
My lord, pending.
We'll call for the case diary. Heard Mr. P.K. Roy Chaudhary. Learned counsel for the petitioner, same order. Call for the case diary. When?
24th.
List this matter on 24th of March.
Item 6.
Lordship, the petitioner is a driver of a vehicle, Lordship, which was intercepted with suspected stolen petroleum. We have the invoice as well, Your Lordship, at an extra.
We'll call for the case diary. Heard Mr. B.J. Mukherjee. List this matter on
23rd.
23rd
Prior
of
to
March.
Eid, Your Lordship.
23rd. Suggested date.
18th, Your Lordship.
18th. Huh? Case diary.
Item 7.
Amita, case diary का formatting जो that perusal of case diary is. Item?
7.
Yes.
Wait, please, lordship. The petitioner is in detention of 187 days. Now your lordship would be pleased to see FIR.
187.
187.
Whether it is, what is the stage?
Charge
Pen-
sheeted case.
Charge sheeted case.
Charge sheeted, all right, my lord. What happened? Your lordship granted bail to co-accused persons. Due to non-compliance of section 47 and 48. Your lordship would be pleased to see the order at page 16, madam.
No, what is your case?
No, my case is this, my lord. That the same thing has happened, that 47, 48 is not complied with.
But that has to be verified.
Verified from CD.
Yes.
Then you can, your lordship may.
Heard
take
Mr.
what you-
M. A. Sheikh, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Perusal of the scanned copy of the case diary would be necessary. Hence, let the scanned copy of the trial court records as well as the scanned copy of the case diary be called for. Let this matter be listed. 13th of March. 30 March.
Item 8.
30 March.
Same note. Charge sheeted 22C, regular bail.
Same order. 30 March. P.K. Roy Chaudhary, Baki.
Item 9.
May I please?
Regular bail application petitioner was arrested on 16/2/2026. Today is 21 days in custody. Lordship will find the FIR.
We'll call for the case diary,
Lo-
giving a short date.
Lordship will call for the case diary, but I have also annexed the statement of the victim, my lord, which says that this petitioner is the headmaster of the school, my lord. He was trying to help the victim, my lord. He has been arrested wrongly, my lord. Lordship will find the FIR page 13. my lord. And I have also collected the statement of the victim, my lord. I have marked Lordship may page once.
Lordship, I'm sorry, Lordship. I cannot understand Lordship, how they have.
No modification.
Huh?
I have marked it.
It is pending investigation.
Yes, my lord. He is in custody.
This is 183 statement.
My lord. That all the victims stated that the headmaster, the present petitioner, he was going to help that other staff, my lord. I have marked for flag mark, my lord. I have.
No, but are you entitled to get a copy of
Yes, my lord.
160?
Also, I thought, my lord, but it is a certified copy.
No, during the pendency of the investigation.
But you will consider the period of detention of the headmaster, my lord. It says that he was going to help that other victim, my lord. He was also shown in the CCTV footage because that's why he was arrested, my lord.
Whether 164, 183 statement is a part of case diary or
It will come.
Will be there.
It will come.
oh, yes, Mr. Sharma.
Regarding the incident, Lordship, there must be other witnesses also, Lordship. Based on two witnesses, Lordship.
Okay, we are calling for case diary, giving a short
My
date.
lord.
Heard Mr. P. Hajorika, learned counsel for the, you take this back.
My lord.
Learned counsel for the petitioner.
Yeah.
Also heard Mr. B. Sharma. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the same. Let this matter be listed when?
20.
20
Yes.
20 March.
Item 10 is also from the same day.
10 same order.
My lord.
20 March.
Ablag. 11.
Please, Lordship. Lordship, the commercial quantity case, my lord, but from the position of the petitioner was nothing was being recovered, my lord.
Charge sheeted case or
No, my lord.
pending investigation?
Pending investigation, my lord.
We'll
45 days behind, my
call
lord.
for the case diary.
Lordship, along with a medical report from the jail authority, my lord, he is suffering from mouth cancer. So that may kindly be also called for, because as per my instruction, he is suffering a lot after detention, my lord.
Heard Mr. P. Das, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the same. Learned counsel for the petitioner also submits that the petitioner is suffering from mouth cancer.
Mouth cancer.
And his condition is deteriorating in the jail. Hence, he prays for calling for a health status report from the jail superintendent. Stop. The prayer is allowed. Let the medical report regarding the condition of health of the petitioner be also called for from the jail superintendent.
That may be called from 2D registry, Lordship, the health report, Lordship.
Okay, registry shall communicate this order to the superintendent of which jail? Central Jail, Gauhati. Let this matter be listed 26th of March.
Item 12,
My lord, in this case, 42 days behind the bar, my lord, the quantity concerned, my lord, 1.83 gram of heroin. Small quantity, my lord. So for the quantity is concerned, but the section 27A has been added, my lord. And lordship will kindly have a look at the case 22, my lord, annexer 4. This is for personal consumption, my lord. He was also admitted in rehab center, my lord.
27A in respect of this much quantity or some other?
27 is also regarding financing.
Nothing of that sort in the forwarding list, my lord, but the section has been added. And lordship will kindly have a look at the certificate, page 23, my lord, that is the
Because
original
21A is bailable.
lordship. 27A will not be attracted in this case. my lord.
Where is the rejection order? Why the try?
Huh? My lord, we have directly approved this honorable court, my lord.
Then we have to peruse the case diary. Heard Mr. P. Das, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Perusal of the case diary would be necessary.
My lord, kindly be short date, my lord, can already because 42 days,
20.
20, my lord.
Let this matter be listed on 20 March.
Lordship.
item 14,
May it please your lordship. Well, here, my lord, in a similar case, my lord, the petitioner were earlier arrested, my lord, and subsequently released on bail. May I take your lordship to the earlier affair, page 30, my lord, regarding the same incident. Same incident, my lord, that Ajra incident, my lord.
Now, what is the submission?
My lord, now, my lord, regarding the same affair, my lord, this affair was lodged on 27/2, my lord, and subsequently they were granted bail. That is at page 27, my
In
lord.
this case, they were granted bail.
Granted bail.
Then again, say,
Then again on the same, my lord, on the same, my lord, incident, there is another affair lodged, my lord, after they have been granted bail. That is at page 14, my lord. Regarding the same Adra incident, same the 27.
a separate affair has been.
Separate affair. Lordship, may kindly say the incident is same. Yes, short affair, my lord. But the incident relates to same, my lord. Same Jari.
Where is the rejection order?
No, not rejection, my lord. It was granted bail.
No, in this second affair.
I can have a bail apply question again. Huh? Second affair bail apply question. Production of 1. 20. My lord, if lordship may take up item number 16, my lord.
No, why is item number 16?
But similar case, my lord.
But in this case, where is the rejection?
Same, the order is there, my lord. Because, my lord, this similar case, same person.
There is a requirement of fund annexing.
But the order is here.
Where?
Item number 16.
This is item number?
Item number 16, page 45. Same incident, my lord.
No, this is not so easy.
But my lord, it is
This,
not
I'll dismiss this bail application for non-compliance of, or you rectify. There is a requirement of annexing the rejection order that you know.
If I'm going to reject question,
We'll take it up after some time. You brief properly. Get the briefing.
It was rejected, my lord. But
where is the rejection order?
It is in the item number 16.
It is not in this case. Then we are dismissing this case.
No, my lord, lordship may kindly see a similar incident.
No. You rectify your defect.
Okay, my lord. Then the lordship may take up item number 16, my lord, similar incident.
Heard Mr. S.M. Abdullah P. learned counsel for the petitioner, who seeks leave of this court to file an additional affidavit for bringing on record the bail rejection order as required under the prevailing notification issued by this registry. The prayer is allowed. When will you
But today itself, day after tomorrow, Thursday.
Let this matter be listed on 11th.
Well, 16th, my lord. Same case.
What is the next item? Wait for your turn.
Lord. Oblige, your lord.
Please, your lord. Intermediate quantity, connected bail application from the same FIR is on 16th, my lord. So this may also be.
Okay, heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner submits that a bail application, connected bail application arising out of the same FIR is fixed on 16th of March. What is the number?
DA number 551 of 2026.
And he prays for listing this matter along with this said application. The prayer is allowed. Let this matter be listed along with bail application number
551.
551/2016 to the 26 on 16th of March.
Item 16.
Yes.
But here the rejection order, my lord, at page 46.
Yes.
And the relevant portion, page 47, my lord. The prayer is rejected. What the fact? 48.
Yes. What is your submission?
But here was a similar, page 48 was the earlier affair, then they got bail, my lord. Then subsequently this affair at page 15 was lost, my lord. And here bail we have raised, it was rejected.
Yes, Mr. Sharma. Are the cases are similar?
There's a few difference.
But incident is same, my lord. Lordship knows, my lord.
Can it be taken up after some time, Lordship? I have to go through in details, Lordship.
Whether this plea was raised before the trial court? You raised this
But
plea.
same court granted bail, my lord.
No, while moving the second bail application.
My lord, I was not the counsel.
Somebody was there.
Somebody was there, my lord.
Whether this plea was taken or not.
But my lord, I was not the counsel.
No, I am not asking whether you are
My
counsel.
taken, my lord, because they will show the bail granting order, obviously. They will show the bail granting order because we.
I'm not asking you to speculate.
Do
you know or not?
As per my instruction, my lord, yes, my lord, they have shown the earlier bail order, my lord, that under similar case they have been granted bail.
Then why it was rejected?
My lord, rejected at page what, my lord? At page 47, my lord, 46. Concerning the offense, initial stage of investigation.
Yes, Mr. Sharma.
Lordship, after some time, Lordship, I'll just go through in details, Lordship.
Okay, let him go through.
Lordship.
We'll take it up after.
Oblige, your lord.
Item 2 of code number 16.
May I please, your lordship? Lordship, third time anticipatory bail application, lordship.
Third time.
Third time. Lordship, my new ground for third time is that, lordship, the petitioner was a subject teacher and suspended from 22nd of August 2025. And in previous two times, neither it was submitted nor lordship considered, lordship. And along with that, lordship, from the for first 3 months of his suspension, he got 50% salary, and now his salary is stopped, lordship. And when his daughter inquired, lordship, the inspector of school, lordship, give this order kindly, lordship, may kindly.
Yes.
His personal appearance is necessary to cooperate the DP and withdraw his salary, lordship. From last 2 months, his salary is stopped and he has a family of two dependents, woman, lordship, and EMI of 68,000 per month, lordship. So.
No, you cooperate in your DP. Where is the difficulty?
Lordship, because he is not in bail, lordship, he cannot cooperate. He's absconding, lordship.
No, in cooperating in departmental proceeding, they will not arrest you.
Lordship may grant some protection there, lordship. CD may be called for an lordship. 6 months have passed and already all kind of investigation is done and only his recording statement is necessary to file charge sheet, lordship. So I am seeking 10 days protection, lordship, to appear before the IO, to give statement and to appear before the IS, lordship.
Where is the earlier rejection order?
Page 40.
Why it was rejected?
What you will find the page 42.
Lordship, it was rejected on merit, lordship.
Paragraph 10, 11.
This time I am not on merit, lordship. I am on my fundamental right. My family's fundamental right is violated and lordship charge sheet is about to file, lordship. Only my statement and if necessary, lordship, I will surrender.
How do you know what is the status of investigation? You are not the investigating officer.
Lordship, one report may be called for along with CD that what is the status and if necessity, I will surrender, lordship. This is third time and last bail.
No, it is necessary you surrender. If you surrender, we'll.
Because if I surrender, lordship, my family will face more hardship, lordship, because salaries, they cannot withdraw my salary, lordship. I have to appear before IS for this, lordship. 10-day protection may be given and after that, if required, I will surrender, lordship, with your dismissal order, lordship. My humble prayer, lordship.
Lordship has already seen the first rejection order. It was again rejected for the second time. In this application, Lordship, no new ground has been taken.
My new ground is, lordship, surrendered.
What is the new ground?
New ground is that he was suspended.
That is a different, totally.
Suspended and now fundamental right is curtailed because of financial hardship and all.
That cannot be a new ground. That is.
And 35(3) notice was not served. And in second bail application, it was rejected at that stage and was not considered, lordship. The police have not given us fair opportunity to appear, lordship. And offense is about 3 to 5 years maximum punishment, lordship. And there are various judgments, lordship.
Yes. 35(3) notice.
That was considered in the second bail application also, Lordship.
Where?
At page 49. Starts with page 46, but Lordship will find.
What is the acquisition?
Section 8 and 12 of POCSO.
Section 8 and 12, lordship.
Okay, we are calling for the case diary.
Paragraph 20, Lordship, may kindly.
Status of.
Page 49, paragraph 20, may see. Lordship, this was also a persuading ground for Lordship to reject his earlier bail application. And in my humble submission, Lordship, no new ground has been taken.
And in lordship, next paragraph 21. Lordship may kindly paragraph 21 also. At that stage, it was rejected, lordship. Now may be considered. Because 6 months have gone and there is a possibility of acquittal also in my trial. I am ready to face the trial. I am a teacher, lordship. There is no chance of absconding, hampering or anything, lordship.
What is your name?
J.S. Ahmed.
Mr. J.S. Ahmed, learned counsel for the petitioner, also Mr. B. Sharma, learned additional public prosecutor. This is for the third time the petitioner has approached this court seeking protection under section 482 of BNSS 2023. He submits that though the offense involved in this case entails punishment for a period not more than 7 years, however, no notice under section 35 within bracket 3 of BNSS 2023 has been issued to him till date. And the petitioner is ready to cooperate in the investigation. Stop. Considering the submission, perusal of the case diary would be necessary, hence call for the case diary. Let this matter be listed.
Along with the report of investigation stage, lordship.
Let this matter be listed on 20th of March.
Short date maybe.
It is a short.
16, 17.
20 March.
Lordship. Plus.
Item 19 of court number 8.
Here, FIR lordship will find page 16, lordship. Regarding this incident, altogether three FIRs were lodged, and the page 16 is the FIR where I'm seeking bail, lordship. 90. May I read the FIR?
Yes.
I have the honor to report that on 9/2/2026 at about 8:30 AM, while I was on official duty along with other police personnel at
What is your name?
mine,
How many petitioners are there?
here, lordship, we have 5 petitioners are before your lordship.
5 petitioners. Okay.
While I was on official duty along with other police personnel at Telipara Toll Plaza, Gusaigaon, it came to notice that a truck bearing registration number AP was illegally parked adjacent to the toll gate, thereby blocking the road and causing obstruction to vehicular movement. When the toll plaza staff requested the driver to remove the said vehicle and clear the obstruction, a large number of persons gathered at the spot and formed an unlawful assembly. The mob started raising slogans, creating nuisance and deliberately obstructing traffic on the national highway, as a result of which the situation became tense and uncontrollable. On receipt of information, I, along with police staff, arrived at the spot and made efforts to clear the road and disperse the crowd. However, the mob turned aggressive and shouted provocative slogans such as Gosaigaon police go back, openly challenging the authority of the police. Subsequently, the officer in charge, Gosaigaon police station, along with the SDPO, Gosaigaon and additional police force arrived at the toll plaza to maintain law and order. Despite repeated warnings and lawful directions, the mob became violent and attacked the police personnel, including the SDPO, Gusaigaon, and the officer in charge, Gusaigaon police station, with the intention to deter them from discharging their lawful duties. The unruly mob also vandalized the Telipara toll plaza, causing extensive damage to toll counters, electronic equipments, barricades, and other government property, resulting in a huge loss to government revenue. During the incident, the below named accused persons, along with others, made provocative and inflammatory statements threatening to create a mini Bangladesh, Pakistan in the area, thereby creating fear, panic, and communal tension among the general public. Due to the violent acts of the mob, public peace was seriously disturbed. Traffic on the national highway was blocked, and government functioning was severely hampered. Now, regarding this, lordship, another FIR was lodged by the truck drivers, lordship, against the toll gate authorities. Lordship, that your lordship will find page 18. May I read, lordship?
Yes. No, what is the gist of this? What do you want to show?
Your Lordship, it is alleged that there was one truck was there, the toll gates demanded some extra money for which there was altercation, and he was also there, he participated in, he was also there, so from him also they took some amount, Lordship. That is the main allegation. So that is that allegation against toll gate by the truck drivers, Lordship.
This is against whom?
Against that toll gate authorities, Lordship, by the truck owner.
Okay, how it is linked with you?
Because regarding the same incident, also, two persons are there. And now third person, Lordship will see that your Lordship will find another FIR that is at page 25, Lordship, starts from page 25. And relevant portion your Lordship will find at page 29. The FIR where I am seeking bail and I have read before your Lordship, that was lodged by a police personnel. Now, page 29 is lodged by that toll gate authorities, Lordship, regarding the same incident, same timing, Lordship. And in fact, in this case, Lordship, the petitioner to arrested, that forwarding report your Lordship will get page 33. Page 33, Lordship will find regarding the same incident. The timing is same, place of occurrence is same by the toll authorities. And in that case, they were arrested on 10/2/2026, Lordship. Immediately on the next day, they were forwarded, Lordship, and they remained in custody. Subsequently, they were granted bail. And even then, even though
all the petitioners.
All the petitioners, that names are there, page 36, Lordship.
Okay. Thereafter?
Thereafter, they were granted bail, but during this period also, so no prayer for sole arrest were made, Lordship. Page 37, your Lordship.
No,
will find that
what
order.
is the difference between this FIR and the
Same
FIR?
incident. The only difference is that one was
Slogan?
one was lost by the SI and one is lost by the toll plaza authorities, and that regarding the slogan part.
Slogan part and the demanding of money part, probably, Lordship. Because in the FIR lodged by the toll personnel, Lordship, there was a statement that some money was
But
demanded.
out of the same incident, when
Yes, and Lordship will kindly see the bail order also in respect of the other FIR at page 37. 37, Lordship will see.
yes,
Lordship will see the third paragraph. It appears that the IO has already recorded a statement of the witnesses and the investigation has been progressed to a considerable extent. Learned APP has raised has not raised any objection in respect of the first FIR, Lordship.
the dates of FIR are different.
No, there will be no Lordship.
No, no.
9/2/26. And time is also
Timing is same.
same regarding the same incident.
Now, what is your submission?
My submission is that Lordship, they were already in custody of the Lordship, and but no, the investigating authority did not file any application for showing them arrest in the present case, Lordship, during that period.
But now, why are you apprehending arrest?
Because the police is calling me to the police station for appearance, Lordship, and this
Yes,
case is
Mr. Sharma.
available and
At this stage, let them appear, Lordship.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the petitioners, namely Lazizul Haq Pradhani, number 2, Saidul Islam, number 3, Rafiqul Islam, number 4, Haider Ali Sheikh alias Haider Ali, number 5, Naushad Ali, who are apprehending their arrest in connection with Gosaigaon PS case number 28/2026 under section 189/191/132/221/117 within bracket 2/324 within bracket 4 of BNS read with section 3 of the Prevention of Damage to Public Property Act 1984. The gist of accusation, next para, the gist of accusation in this case is that on 9/2/2026, one Hirok Jyoti Sharma, SI of Police of Gosaigaon Police Station, had lodged an FIR before the officer in charge of Gosaigaon Police Station, inter alia, alleging that on 9/2/2026 at about 8:30 AM, an information was received. Now it came to the notice of the police that one truck bearing registration number AP39/UU-2977 was illegally parked adjacent to toll gate near Telipara Toll Plaza, and it is further stated in the FIR that due to the illegal parking of the said truck, the vehicular traffic was obstructed. And when toll plaza staff requested the removal of the said vehicle, a mob gathered there and started raising slogans against police, and also started shouting provocative slogans. Stop. It is further alleged in the FIR that when the police arrived there and tried to maintain law and order, the mob became violent and attacked police personnel, including the SDPO Gosaigaon and the officer in charge of Gosaigaon Police Station. It is further alleged that the mob also started making communal slogans and were led by the FI named accused, namely Rafiqul Islam, Haider Ali, and Abdul Halim. Learned counsel for the stop. Next para. Mr. A. Ahmed, learned counsel for the petitioner, has submitted that in respect of the said FIR, in respect of the same incident, an FIR was also lodged by the owner of the truck which was parked at the spot. And on the basis of the said FIR, Gosaigaon PS case number 30/2026 was registered. He further submits that a third FIR was also registered in respect of the same incident. The said FIR was filed by who is the third FIR?
Their lordship, the authorities of Toll Plaza, lordship.
Filed by one Mukesh Kumar. Mukesh Kumar.
Manager of the.
Who is the manager? Who is stated to be the manager of the Telipara Toll Plaza? Learned counsel for the petitioners submits that all the petitioners were apprehended in the case which was registered on the basis of the third FIR filed in the incident. That is Gosaigaon PS case number 29/2026. He further submits that later on, the petitioners were granted bail by the court of learned SDJM M. Gosaigao in Gosaigao PS case number 29/2026 on 21/2/2026. He also submits that while how many days you were in custody?
There were around 11 days, Lordship.
He also submits that during the period when the petitioners were in custody in connection with Gosaigao PS case number 29/2026, no prayer for arresting them in connection with the Gosaigao PS case number 28/2026 was made. However, now the police is searching for the petitioner after they got bail in the Gosaigao PS case number 29/2026. He submits that since the subsequent FIRs are filed in connection with the same case, same incident, what is your submission?
Regarding the same incident, Lordship, then that this was a prior case, Lordship, that ultimately it will be amalgamated subsequently.
Same incident, separate cases ought not to have been registered. He further submits that the petitioners are ready to cooperate in the investigation of Gosaigao PS case number 28/2026. However, since they are apprehending that they may be arrested in connection with Gosaigao PS case number 28/2026, they may be granted some protection. Stop. On consideration of the submissions made by learned counsel for the petitioners, it appears that perusal of the case diary of Gosaigao PS case number 28/2026 as well as Gosaigao PS case number 29/2026 would be necessary in this case. Hence, call for the same. Call for the same. Fixing, let this matter be listed again on 30 March. However, in the meanwhile, considering the submissions made by learned counsel for the petitioners, as discussed in the foregoing paragraphs, the petitioners are directed to appear before the investigating officer of Gosaigao PS case number 28/2026 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Gosaigao PS case number 28/2026, they shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to following conditions. Condition number 1 and 2. Hasnain. Abhishek or condition. Let this matter be listed on 30 March.
Obliged.
Finding item 16.
My lord, it may also come along with item number 14, my lord.
Heard Mr. S.M. Abdullah P. learned counsel for the petitioner. Also heard Mr. B. Sharma. Learned counsel for the petitioner submits that since a connected bail application, that is bail application number 661/2016 is fixed on which day? On 11th of March. He prays that this matter may also be taken up along with the same. The prayer is allowed. Let this bail application be listed on 11th of March 2026 along with bail application number 661/2026.
I'm obliged, my lord. But the incident is similar, my lord, is also found out. All right.
Item 21.
May please, my lord. Well, this is a criminal revision, my lord. Asserting the judgment passed by the Honorable Session Court, my lord, in criminal revision one. What is the matter, my lord, is that the present respondent, she had filed a maintenance case under section 125, my lord. Claiming
Second revision,
second revision.
whether it is maintainable.
Well, it's maintainable because I'm selling the order, my lord. She is claiming maintenance of rupees 8,000 per month, 10,000 per month, my lord. Initially, which was granted by the learned trial court, my lord. Thereafter filed the present subsequent revision petition, my lord. That was dismissed. Against that, I have preferred the present revision petition. My lord, the facts, I'll just put the facts of the case, or gist of the case, my lord. She is alleging that the present respondent is alleging that the present petitioner is the husband. And they got married by way of a Kabin Nama on 7/8/2020. Now, my lord, in my written statement, I'm specifically taking the stand that the Kabin Nama was not proved as per law. And the signatures that were appearing in the Kabin Nama, those were obtained fraudulently, my lord, in a coercive manner. But the learned, both the courts below, my lord, have not taken that aspect of the matter, that the Kabin Nama was not proved. There's the signatures were obtained by force.
No, is it an application under 528 or 438?
Well, my present petition, my lord,
Yes.
it is 438.
Heard Mr. A. Iqbal, we are issuing notice. Heard Mr. A.
The
Iqbal,
records may also be called.
learned counsel for the petitioner. This application under section 438 of BNSS has been filed by the petitioner Ariful Islam, impugning the order dated, judgment dated 2/1/2026, passed in criminal revision number 1/2024 by the Court of Learned Session Judge Kokrajhar. Whereby the order dated 22/11/2023 passed by Learned CGM Kokrajhar in Miss Case number 22M/2020 was upheld. Issue notice to the respondent and call for the scanned copy of the records of
Miss case number 20.
Miss Case number 22M/2020, as well as records of criminal revision number 1/2024 from the concerned courts. Registry to take steps for requisitioning the records. The petitioner shall take steps for issuance of notice on the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April, list according.
At least till the next date, my lord.
What?
Maintenance amount, my lord, 8,000. That may be decreased, my lord, 5,000.
No.
Item 22.
Of less.
Big loss.
Yes.
First, my lord, I just want to take lordship to annexure 1, page 9.
What is this?
It is in my lord, criminal represent petition, my lord, against a
Appellate's court order.
my lord, date against the order dated 6/2/2026 passed by the Land Museum, Sirang, my lord. In the Anasia case number 11/2025, my lord.
No, this is amenable to appeal. The CJM's court order, the order which you have impugned here, appeal lies against that order.
No, my lord, there's an, we have already the honorable passed an order, my lord, in the same matter, my lord, honorable this court passed an order, my lord. I just want to place the order that is 6/2/2026. Similar matter, my lord.
No, which is the impugn order in this?
6/2/2026, my lord.
No, what is this? What you are showing? What is this?
Impugned order is, my lord, actually 6 cases were lost against me, my lord. I'm just giving the brief of this, very very short period, my lord. And thereafter, we filed a criminal revision petition against that matter, my lord. Subsequently, all the 6 cases were dismissed by the Honorable Court, and Honorable High Court, my lord. And thereafter, my lord, we filed criminal revision transfer petition, my lord. And that transfer petition was not allowed, but my presence is allowed to be recorded through video conferencing, my lord. Because I have been suffering from illness, my lord, severe illness, my lord. I have annexed medical documents here, my lord.
No.
I will cooperate with the.
No, Mr. Rahman. Why this revision has been filed? Against which impugn order? Which order you have?
Yes, my lord. 6/2/2022.
Where is the impugn order?
My. It is on, my lord, page 54, Annex 6, my lord. Only I'm just reading out the relevant portion for lordship's kind convenience, my lord. Complainant shall take steps.
No, don't read. You tell me what has been directed. No,
Someone has been issued.
summon has been issued. Summons is issued in, what is this NICR case? Negotiable instrument.
A negotiable instrument, my lord. Case number 11/22, 2025, my lord.
Summons were issued to you.
Against me, my lord.
Okay. Then
Then, my lord, I filed an application, my lord. I filed an application before seeking, my lord, personal appearance exemption, my lord. And that was also, my lord, rejected. As because I stay in, my lord, in Gauhati now, as I have been suffering from serious ailments, my lord, I may be allowed to, through video conferencing, my lord. Only that much prayer, my lord.
but this, whether revision lies against this order, 6 orders, this is an interlocutory order, only directing you to appear before issuance of summons. What is your prayer? How this order is wrong?
My lord, I may be allowed to appear through video conferencing, my lord, which is also there in.
That is not the prayer before this court. Have you made that prayer before this court? You have not challenged that order by which your video conference. Where is that order where the prayer for video conferencing was rejected?
60, my lord.
Where is that order?
6/2/2026. That is the order, my lord.
No, that is the order by which summons were issued to you.
No, my prayer was rejected, my lord. Send the petition number. First portion, my lord. Send the petition number 105/26 filed by the engaged counsel. So and so on behalf of the accused, seeking leave for appearance of audio, video, electronic means. Exempt.
But this is an interlocutory order against which revision does not lie. Whether revision lies against such an order.
But I will take instruction, my lord. Let me.
What instructions?
Take instruction, my lord. So there, let me matter be listed after a week, my lord.
Heard Mr. S. Rahman. learned
Time
counsel,
SS A. Rahman, my lord.
SS A. Rahman, learned counsel for the petitioner. This application under section 438 of BNSS has been filed by the petitioner Fakhruddin Ali Ahmed, impugning the order dated 6/2/2026, passed in NICR case number 11/2025 by the Court of Learned Chief Judicial Magistrate Siraj, whereby prayer for dispensing with the personal appearance of the petitioner in NICR case number 11/2025 and allowing him to appear through video conferencing was rejected. Stop. A query was posed by this court to the learned counsel for the petitioner as to whether, in view of the fact that the impugned order appears to be an interlocutory order, a revision lies under section 438 of BNSS, learned counsel for the petitioner seeks some time to answer this query.
Fine.
The prayer is allowed. Let this matter be listed when?
Subject to lordship's convenience.
18th of March.
Highly obliged.
Item 23.
A to return the Take this back.
May it please the court. Here, my lord, petitioner was the my lord complainant in a my lord NI proceeding, my lord. And the my lord respondent herein, my lord, he is the my lord accused, my lord. And in the trial court, my lord, the respondent was my lord convicted by 1 year, also my lord, to pay a fine of rupees 4 lakhs, my lord. Against that order, my lord, an appeal was filed, my lord. And in the appeal, my lord, the respondent was my lord acquitted, my lord. And
Okay.
stated his liberty, my lord. So, my lord.
Okay, heard Mr. K. Burra, learned counsel for the petitioner. This application under section 442/438 of BNSS has been filed by the petitioner Shri Amit Kumar Paul, impugning the judgment and order dated 3/12/2025 passed by the Court of Learned Additional Sessions Judge number 1, Kamrup Metro, in criminal appeal number 122/2016, whereby it has allowed the appeal filed by the present respondent and has set aside the judgment and order dated 29/4/2016, passed by the Learned Subdivisional Judicial Magistrate Kamrup Metro in CR case number 1405/2012. Stop. Issue notice to the respondent and call for the records of the criminal appeal number 122/2016 as well as CR case number 1405/2012 from the concerned courts. The petitioner shall take steps. No, sorry, the registry shall take steps for requisitioning the aforesaid records. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April. Please check out.
Item 24.
May I please the lordship? Lordship, in this case, the petitioner is aggrieved against the order dated 21/2/2026, passed by the learned additional district session judge to Kamrup Metro, whereby at the time of condoning the delay of 23 days, the court allowed the prayer of condonation but imposing a precondition of 30,000 rupees cost to the present petitioner. For a moment, if your lordship peruse the impugned order, lordship will
No,
find it
what is the wrong? What
only
is there?
23 days delay. The court itself admitted that 23 days delay is inordinate delay as per Issa Bhattacharya's judgment. And I have sufficient reason already shown my sufficient cause. Court satisfied on that part. Thereafter, court imposed 30,000 cost.
But court can impose.
Lordship, court can impose, but if the delay is an inordinate delay, suppose 1 year, 9 months or 2 years, and I have not reduced sufficient cause at the time of filing the delay condemnation episode, then accepted. The court may impose 30,000 rupees cost or something else. But if the delay court itself admit that delay is 23 days delay is an inordinate delay, and I have satisfied the court by showing sufficient cause, then therefore I agree against that order, Your Honor.
The original case was
The
NI.
domestic violence matter is it was an ex parte judgment against the present petitioner. Thereafter, I challenged that ex parte judgment before the appellate court under section 29 of the DV Act. While referring the appeal, there is a 23 days delay. And I am not on that, my lord.
You are agreed with the imposition of cost.
Yes,
only imposition.
Yes, only imposition of cost. Otherwise, delay is condoned. Delay condoned, court directed us to pay the amount and proceed with the criminal appeal. But I have to pay the 30,000, otherwise it will be considered as it is barred by limitation. If I fail to pay the amount by tomorrow.
By?
Tomorrow. Tomorrow is the next day, 10/3. If Lordship may peruse page number 61, last portion, is a fixed 10/3/2026 for payment of cost and necessary order. And page number.
What do you do?
Lordship?
What do you do?
I am presently working as a washer in a canteen of Air Force Authority, and the agri person also a government employee. She is earning more than 30,000, 34,000 rupees per month. She is also earning lady. Despite that, the court passed an order. I am not on that because it was an ex parte judgment. I'll submit my part on that time of appeal. But the thing is that if the court imposed some condition at the time of admission of the case, then it's a different thing. That there is an outstanding amount, you have to pay this much of percentage of amount, then only I will admit the case. I'm not on that. That is also I am agree with that. But for 23 days of delay, Lordship, 30,000 rupees cost. For a moment, if your Lordship peruse, for a moment, page number 59 of my petition, para 7. This is the observation of the court. Lordship, may kindly say.
Page number?
59. Para 7 of the impugned order. This is the observation made by the learned court below.
Please read.
Bearing this principle in mind, this principle means Issa Bhattacharya's judgment, this in page number, para number 6, Lordship. I am reading from para number 7. Bearing this principle in mind, the court has considered the explanation offered. The delay is a 23 days delay only, a short duration by any measure, and not inordinate in the list. The period from 11/7/2025 to 22/7/25 was occupied by customary death rituals following the petitioner's elder brother's bereavement. This coincides almost exactly with the period.
Is it an illegal order? It is not an illegal order.
I cannot say it's an illegal because passed by a court below. I am saying that if my submission is only is that if the delay is an inordinate delay or I cannot explain with sufficient cause, then court may impose cost. Normally it happens in every court of law. But if the court is admitted the 23 days delay
may
only.
Condone the delay subject to certain conditions. Imposition of cost may be one of that condition.
Maybe. But the thing is that where from the court satisfies that imposition of cost is necessary. If court itself satisfied with my sufficient reason, cause, and then court says that it's an inordinate delay not inordinate delay, it's a small delay, duration of 23 days only, preferring the appeal. because for preferring the appeal only, we get 30 days as per DV Act. Any order passed by a judicial magistrate is appealable under section 29 of the Act, and for that we get 30 days time. After expiry of 30 days, 23 days delay, admittedly. And my brother expired, I have to do some rituals in my Mazuli, in my native place. I was ill. I have submitted medical document. Everything is there. And most interestingly, the proceeding was proceeded ex parte in the trial court. I am not on that. Due to some miscommunication and something with my earlier lawyer, I am not blaming anyone. The thing is that, my lord, whether for 23 days delay.
What was the order by the trial court in DV?
Court directed me to pay 12,000 rupees
Per month.
Whereas admittedly, the court observed that as in a certain liability, the aggrieved person admitted that she is earning 34,000 rupees and she is a government employee. Admittedly, court directed me to give an alternate accommodation of 7,000 rupees to the aggrieved person and the son. But the thing is that, my lord.
Okay, we are issuing notice. But no stay.
Then matter infractions, lordship. Because why? Because tomorrow is the date fixed. If lordship issue notice only, then we have to pay the 30,000 by tomorrow itself.
Yes, you pay. If ultimately it is found by this court that cost is high, you will get a refund.
Lordship, proceeding.
No. Otherwise, in revision, we cannot go into the aspect of exercise of discretion. We are ready to issue notice.
Yes, lordship, but consider.
But no stay.
23 days delay only. It
No.
is not the court
That aspect will be considered whether court is having that power to impose a cost. That is the only question which is agitated in this appeal.
I am not denying on that. Court may impose cost.
How much? That is.
It is the discretion of the court, but considering the case, nature of the case, my lord, only 23 days delay. Court admitted that it is not an inordinate delay. Court also satisfied with the cost produced before the place before the honorable.
Okay, we are ready to examine your contentions, yes. But no.
Can be shorted may be given and that I may be.
No.
Lordship may kindly stay the proceeding. Shorted may be given. Let them appear. I will satisfy this honorable court. But if lordship will not, it's my prayer, lordship, because if your lordship not accept my stay, then it's then it become infructuous, my lord. Because
no, it will not become.
Tomorrow I have to pay 30,000 rupees.
It will not become infructuous. If ultimately it is found that you are not required to pay, you will get it back or it will be adjusted. Heard Mr. P.P. Bhattakur, learned counsel for the petitioner. This application under section 438 of BNSS 2023 has been filed by the petitioner impugning the order dated 21/2/2026 passed by the Court of Learned Additional Sessions Judge number 2, Kamrup Metro?
Yes,
Kamrup Metro. In Ms. J case number 19/2025, whereby the appellate court had condoned the delay of 23 days in preferring an appeal against order dated 21/6/2020 on against an ex parte order dated. Where is that order?
Lordship. Lordship will find in page number 24 is a 15/7/2025.
Order dated 15/7/2020.
In DV case number 111/2017.
In DV case number
111 of 2017.
2017. Stop. The petitioner is mainly aggrieved by the imposition of cost of rupees 30,000 by the appellate court as a condition for condoning the delay. It is further submitted by learned counsel for the petitioner that time for depositing the said cost is granted by the first appellate court till tomorrow, that is till 10th of March 2000. We are extending this time for some time, but no stay. Stop. Issue notice to the respondent and call for the scanned copy of the Ms. J case number 19/2025 from the trial court. Stop. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode. Respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 1st of April. Learned Mr. B. Sharma, learned additional public prosecutor, appears for respondent number 1. Stop. Though this court is not inclined to grant any stay of the impugned order at this stage, however, the time for depositing the cost imposed by the first appellate court in the said court is extended for another 15 days. Stop. List this matter accordingly on 1st of April.
Item 25.
This revision or suppose against upholding of the trial court judgment in order, your lordship, by which petitioner is convicted and sentenced for 3 years, your lordship.
NI case.
Lord, not NI case, but under section 354 and 354A of the Indian Penal Code, your lordship. And I is for your lordship allowing him to remain in bail, your lordship.
The trial court convicted you.
Lord.
First appellate court
Appellate
upheld.
court upheld that.
Then
Against that, I have come before this.
what are the grounds? Why
Grounds
this?
here, basically, your lordship, is this, your lordship, the case there's projected by the prosecution is this, your lordship, that first of all, your lordship, by coming by a vehicle, your lordship, the car, your lordship, that the person concerned, your lordship, in the middle of the road, your lordship, put out his hand and grabbed the breast of the victim. That is the case, and your lordship will find that that vehicle which has been seized by the police, there is no material has been placed before the honorable court, the linking that vehicle with in my name. That is first ground on which your lordship, because ultimately your lordship will find that that is a very vital aspect of the matter, that vehicle. That vehicle has seized not from me, seized from somewhere else, not in my name. There is no attempt on the part of the police to link that vehicle with me.
No, vehicle need not to be linked. The offense is under 354.
Yes, but the very allegation is that while coming through that vehicle and in a running position, I have commissioned the offense.
Whether witnesses are there?
Yes, some of the witnesses are there. And secondly, your honor will kindly, your lordship will kindly.
Now, in this revision, how far we go, can we appreciate the evidence?
No, your lordship will find if there is a perversity.
Now, what is the perversity?
Your lordship will find that there are certain discrepancies which did not consider at all by the learned court below, lordship, and that including that the time of the incident.
What is the punishment?
3 years, maximum punishment that has been.
You are on bail or behind the bars?
No, I am on bail. Your lordship may call for the issue notice at this stage. And in fact, I have not annexed those FIR copies, etc. also along with this. I would have, I would like
No,
to.
but for issuance of notice, you have to make out a case.
No, your lordship will kindly see that so far as this is concerned, that there are certain discrepancies which one I have pointed out, and second, the time is very important in this particular case. They says in the month of April, one witness says it is at 4:45, and the prime witness says it is, one eyewitness says it is at 4:45 the incident took place, and one witness says at 5:45 this incident took place. And if it is at 5:45 on 9th, then your 9th of April, then it will be dark. And some of the witnesses who claim to be eyewitnesses, it would have not been possible for them to see the face of the accused persons from a distance, your lordship. And that aspect has also not been considered by the honorable court. There is a predetermined approach altogether. And thirdly, your lordship will find that there is a plea of alibi and that there is a space. And another aspect, the FIR. If your lordship go to the FIR, the incident took place on 9th. The witnesses says that incident has taken place on 9th and they have gone to the police station, but police asked us to come on next day, that is on 10th. On 10th, they say the FIR lost, and a police record, which is part of the record, which has been exhibited, and even the search sheet mentioned that FIR has been lost on 11th. Now, these discrepancies, we cannot brush aside altogether. This has ultimately, your lordship will find the person will go to jail for this offense if your lordship does not admit this petition. And if there are certain discrepancies which I can point out, lordship, and it is a case where those discrepancies exist, these discrepancies together make
Yes,
such a
Mr.
case.
Sharma, anything?
Lordship, here there are 3 eyewitnesses to the incident. There are some discrepancy, Lordship, regarding the time. But otherwise, Lordship, if you tally with the statement of the victim, Lordship, there is no doubt, Lordship. And he has been identified, Lordship. They have seen him during the incident. So the case rests on that only, Lordship. If Lordship permits me, I can point out the relevant portion, Lordship. It's very specific, Lordship. There is no ambiguity towards that effect, Lordship.
No, in this revision, we have very limited area.
No. So far as the revision of jurisdiction is concerned, your lordship has power circumscribed. But normally, your lordship, when 3 years, your lordship.
No, but do you have a case?
I do think, your lordship, I have a case to place before this honorable.
Had Mr. S. Bhattakur, learned counsel for the petitioner. Also had Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of BNSS has been referred by the petitioner, Shri Pondesh Singh alias Jeep Singh, impugning the judgment and order dated 10/12/2025 passed by the Court of Learned Sessions Judge Dima Hasao in Criminal Appeal number 3/2025, whereby, the appellate court upheld the judgment and order dated 18/11/2025 passed by the Court of Learned Chief Judicial Magistrate Dima Hasao in PRC case number 37/2022, whereby the appellant was convicted under section 354 IPC as well as 354A IPC and 509 of the IPC, and was sentenced to undergo rigorous imprisonment for 3 years and if to pay a fine of rupees 10,000 under section 354 IPC. He was also sentenced for rigorous imprisonment for 1 year and to pay a fine of rupees 5,000 under section 354A of IPC with default stipulation, as well as to simple imprisonment for 6 months and to pay a fine of rupees 5,000 with default stipulation under section 509 of the Indian Penal Code. I have gone through the grounds on which this revision has been preferred. Issue notice to the respondent number 2 and call for the records of sessions case. Now call for the records of criminal appeal number 3/2025 from the Court of Learned Sessions Judge Dima Hasav, as well as the record of PRC case number 37/2022 from the Court of Learned Chief Judicial Magistrate Dima Hasav. The registry to take steps for requisitioning the records. Any prayer?
For your lordship remaining in bail, allowing me to remain on bail.
Learned Counsel submits that the petitioner is already on bail granted by the court. Of which court granted you?
Your lordship on this honorable court, as an anticipatory bail, and then lordship by the court of trial court. Yeah.
Granted by first appellate court.
Granted bail.
Granted.
I'm on bail all along.
Granted by the trial court as well as first appellate court. The petitioner is allowed to remain on previous bail
Lordship.
till during the pendency of this revision petition. Let this matter be listed at the date the occurrence. May 6th. Let this matter be listed on 6th of April.
Deeply.
Item 29.
My please, lordships. Lordship,
Yes.
this revision is against the impugn order dated 6/12/2025 passed by the learned CJM, rejecting the plea of the petitioner for giving custody of his vehicle, lordships. Lordships, may kindly see the page number 14, lordships. The impugn order, lordship.
This is an application under which provision? 438 or 528?
438, lordship, 442, there is section 528, lordship. Or the VNSS, lordship.
Which power should I exercise? Under 438 or 528?
Your lordship, your lordships. Unlimited your lordships.
Yes. Mr. Sharma.
The excise is a party.
Excise.
Lordship.
Who is appearing? Mr. Gogoi is appearing. You have served notice on the council.
Yes, lordship, I have made a party, lordship, page number.
But have you served
Yes, lordship, you have served a copy, lordship, to the.
on whom?
My advocate class has served the copy, lordship, there has been access.
Served a copy on whom?
Take instruction, but I made party, lordship, standing council excise, lordship. Page number 2, lordship. And the code is also reflected. Standing council excise, lordship.
This application under section 438/528 of BNSS 2023 has been made by the petitioner Kanak Payang, impugning the order dated 6/12/2025 passed by the Court of London, Chief Judicial Magistrate Dhemaji, in connection with Excise Circle Case number 530/2025 under Section 53 within bracket 1 within bracket small a of the Assam Excise Act, whereby the prayer made by the present petitioner seeking custody of the vehicle bearing registration number AS03 CC 2450 was rejected. Learned counsel for the petitioner has submitted that the petitioner has already served notice of this case to the Standing Council Excise Department. It also appears that the name of the Standing Council Excise Department is reflected in the cause list. However, no one is present. Why your prayer was rejected?
So my prayer was rejected because Lordships, the IO has reported that Lordships, the vehicle is required for the fire inspection as well as so that he has initiated conspection process, Lordship. At page number 14, Lordship, pair number 2, Lordship. May I read, Lordship?
No. Let the scan copy of the records of Excise Circle case number 530/2025 be called for from the concerned court. The Standing Council Excise Department is also directed to take instructions regarding the status of any confiscation regarding the fact, if any, whether any confiscation proceeding is pending in respect of the aforesaid vehicle. If so, the status thereof. Let this matter be listed at the short date. 26th March.
Oh, like Lordship.
Item 31.
Here we have challenged the criminal proceeding instituted against the petitioner, my lord. My lord will find the FIR page 13, 1-3.
What is the stage?
My lord, charges have been filed, now evidence will start.
On what ground you are challenging?
My lord, there is no ingredients of the section, my lord, section 420, my lord.
Then why charges were framed? Have you challenged the charge framing order?
What?
Have you challenged?
My lord, we have challenged the whole proceeding, my lord. Whole criminal proceeding, my lord.
No, you should have, if your case is that charges ought not to have been framed, you should have.
Well, whole proceeding has been put to challenge, my lord.
At what stage you can put that challenge?
Well, the FIR, if we challenge only the FIR, but even if we don't challenge the whole proceeding, if we challenge the FIR even at a later stage, my lord, if the initial step of that is FIR is not maintainable, my lord, then whole proceeding goes, my lord. But here we have not put to challenge only the FIR, but the whole proceeding.
On what ground?
Yes, ma'am. My lord, kindly see the FIR. May I read, my lord?
No, when you could have. Okay, let me hear you. What is your?
My lord
Yes.
has gone through the FIR or?
No. What is the accusation?
Accusation, my lord, there's cheating in the examination.
You are that candidate.
My lord.
Yeah, okay. Then
Now, my lord, you kindly see the ingredients of 420, my lord. That one. But to show the ingredients of the 420, my lord, may I rely on paragraph 18 and 19 of the judgment, my lord.
when charges were framed against you?
That order, my lord, you'll find it page
When?
27, 812, page 27, my lord. 8/12/2025.
It's 27.
Your case is 420 materials are not there.
Materials are not there.
Then you could have pleaded for discharge.
If the
And if you are not discharged, then you could have agitated the order of framing charges. That too under 438, where there is a limitation. To overcome limitation, can you come under
This is
528?
under 528, my lord.
Yes, merely because you are barred by section 438.
No, my lord, I'm not barred, my lord. It is to January, December, my lord.
Okay,
3 months is. No, my lord, I will beg to rely on paragraph 18 and 19 of the judgment, my lord, I just placed before your lordship.
yes,
Paragraph 18 and 18, my lord. Here, the ingredients of cheating is been given, my lord. 1, 2, and 3. May I read it, my lord?
yes,
The deception of a person, this is the ingredients of cheating, my lord. Deception of a person either by making a false or misleading representation or by dishonest concealment or by any other act or omission. The secondly, my lord, fraudulently or dishonest inducement of that person to either deliver any property or to consent to detention thereof by any person or intentionally induce that person to deceive, to do or omit to do anything which he would not do or omit if he were not been so deceived. Such an act or omission causing or is likely to cause damage or harm to that person is in body, mind, or reputation or property. This is cheating, my lord. Now, paragraph 19. To constitute a offense under section 420, there should not only be cheating, but as a consequence of such cheating, the accused should have dishonestly induced the person deceived to deliver any property to any person, or to make, alter, or destroy wholly or in part a valuable security or anything signed or sealed which is capable of being converted into valuable security. Now, my lord, where is the property involved, my lord, here? No ingredients of 421. And they have, in the FIR, they have said that the student has violated point number 7 and 12. Am I with your lordship, my lord? They, in the FIR, they have said, my lord.
yes.
In FIR, they have, they are saying that the student have violated point number 7 and 12. Now, my lord, kindly have the point number 7 and 12, my lord, page 28. Am I with your lordship, page 28?
Yes.
7. Mobile phone, smartwatch, calculator, bags, ornaments, or any other electronic gadgets and any printed materials are not allowed inside the examination hall premises of the test venue. Anyone found violating these rules shall be barred from appearing in the test, and his or her candidature shall be rejected. That is the punishment, my lord. And 12, my lord, candidates are warned that any attempt to use unfair means in the examination or any breach of or attempt breach of examination rules shall make them liable for expulsion. The candidate is already expelled, my lord. From the affair, it is revealed, my lord. She has already been expelled. Now, my lord, we'll kindly see the ingredients of the offense, my lord, whether that offense has been committed under 420. For the violation of the rules, my lord, she has already been expelled.
Yes, Mr. Sharma, anything?
At this stage, no, Lordship.
Heard Mr. P.K. Munir, learned counsel for the petitioner. This application under section 528 of BNSS, 2023 has been filed by the petitioner, namely Asmina Khatun, alias Asma Khatun, praying for washing of the entire proceedings of PRC case number 143/2025. Stop. The gist of accusation in this case is that on 30/4/2023, one Kumud Sharma, officer in charge of Mushalpur police station, had lodged an FIR before the officer in charge of Mushalpur police station, inter alia alleging that on 30/4/2023, an information was received on 30/4/2023 during what examination?
TET examination.
TET examination held in Mushalpur Higher Secondary School in between 1:30 p.m. to 4 p.m. The petitioner was found using mobile phone in the examination hall, and it was found that she had taken the photograph of the question paper and sent the same to her husband and got reply back from other mobile phone. Learned counsel for the petitioner has submitted that though on 8/12/2025, the trial court has framed the charges under section 120B/420 of the Indian Penal Code, read with section 34 of the Indian Penal Code. Against the petitioner. However, no ingredients of section 420 has been made out in this case. He further submits that the allegation that the present petitioner has violated violated the rules and regulation as mentioned in point number 7 as well as 12 of the instructions issued by the authority conducting the TET examination does not lead to commission of an offense under section 420 of Indian Penal Code, as the ingredients of the said offense are not fulfilled in this case. In support of his submission, the petitioner has cited a ruling of the apex court in the case of Muhammad Ibrahim and others versus State of Bihar and another, reported in 2009 8 SCC 751. Stop. I have gone through the materials available on records as well as the citation referred to, as well as the ruling referred to by the learned counsel for the petitioner. Issue notice to the respondents. Since the learned additional public prosecutor has already appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondents by speed post as well as by usual mode. Let the scanned copy of the records of PRC case number 143/2025 as well as the connected case diary of Mushalpur, scan copy of the connected case diary of Mushalpur PS case number 43/2023 be called for from the trial court. The registry to take steps for requisitioning the scan copy. Let this matter be listed again on 7th of April. The further proceeding of PRC case number 143/2025 shall remain stayed till next returnable date. List accordingly.
Here two petitioners. No?
Yes, but Asma, there are two petitioners, Asma Khatun and Moidul Islam. Yes.
Deeply observed.
Bail hearing here, item 15 of court number 16.
May kindly peruse last order. Dated 17/2/2026.
Yes. What has happened to notice?
Lordship, instruction has not been received.
Already 9 months behind the bar and this.
Amicus may be appointed in that.
Yes,
Amicus list. So, heard Mr. H. Agarwal, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the learned additional public. Okay, scan copy of the case diary has been. It on perusal of the office note, it appears that the scanned copy of the trial court records as well as connected case diary has already been received. However, learned additional public prosecutor submits that he could not gather information regarding service of notice to respondent number 2. He, however, fairly submits that an amicus curiae may perhaps be appointed to defend the cause of respondent number 2 in this case. Any amicus in the courtroom? Apart from Mr. Nawaz, anybody else? This court is inclined to appoint amicus curiae to defend the cause of respondent number 2. Accordingly, Mr. Sarfaraz Nawaz is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this bail application. The learned counsel for the petitioner is requested to furnish a copy of bail application along with the annexures to the newly appointed amicus curiae. Let this matter be listed when?
Your lordship,
23rd March.
23rd March. কত এই লিস্টখন চেঞ্জ হয়েছে আপ টু ডেটলি এইখন
Item 16.
lordship, yes, can copy earlier rejected, lordship, can it be on any other day, lordship? Today I could not go through the same.
and copy is there.
No, my lord, the record was not called for, my lord.
Oh, today it has come up for motion because lordship, on the last occasion, they could not satisfy your lordship regarding the why the scan copy.
No. On last occasion, you submitted that some additional ground.
Yes.
My
You want to file additional affidavit.
My lord, on the first
Have-
occasion, my lord.
Have you
the-
filed additional
My
affidavit?
lord, I have filed.
I say. What are the additional grounds?
That additional ground is that, my lord, apart from, my lord, other grounds, my lord, I have taken a new ground. That is, my lord, though notice under section 47 was served, my lord, but that was not properly served, my lord. Because in the, my lord, kindly see.
Okay, we'll call for the scan copies. Heard Mr. A.K. Azhar, learned counsel for the petitioner. It appears that in pursuant to the order dated 19/2/2026, the petitioner has filed an additional affidavit wherein certain additional grounds for seeking bail by the petitioner has been taken. Stop. It also appears that perusal of the scan copy of the trial court records would be necessary for consideration of the instant bail application. Hence, let the scan copy of the trial court record along with the scan copy of the connected case diary be called for from the trial court registry to take steps for requisitioning the scan copy. Let this matter be listed on 27th March.
27 number.
Item 17.
17 is the same order,
Same lordship,
same matter.
same case lordship.
17, same order.
Published.
Item 39 of court number 8.
May I please, your lordship. Lordship, my senior is in another court. Kindly the matter may be passed over for typing.
Here lordship, the notice upon the respondent number 2 has been served. They are already appearing lordship, I'm sorry.
Yeah. My lord, for a moment. my lord.
Somebody has appeared.
Yes, somebody is appearing lordship.
Who?
She is appearing lordship.
Mr. Tijouri said.
Who?
Amicus, Tijouri.
Okay, we'll take this matter after some time.
Highly.
Item 40.
My lord, this matter may be taken up at 2, my lord. My senior is on leaves.
We'll take it up in the second half.
Right.
Not at 2.
My lord.
item 43.
Please, your lordship.
আৰু এটা আইটেম মোশনত আহিছে নে? এইটো হিয়াৰিঙত মাতিব লাগিব।
Your lordship.
Yes.
This is the case where, my lord, no, I'm making a novel submission today in this aspect. It involves the interplay of the Drugs and Cosmetics Act and the NDPS Act. Because there's a notification by the central government which says that when in case of a manufactured drug such as codeine, if the percentage of the codeine in that is less than 2.5%, then it is not to be considered as a manufactured drug. But this plea, when it was taken up before the learned trial court, the trial court relied on Hira Singh, saying that the drugs and the neutral substances are not to be taken separately, but they have to be taken together. So on that pretext, the ground that plea was rejected, but that was not the contention. The contention was not.
Yes.
Contention was not that we were seeking that only the drug elements be weighed. But then there's a the central government notification which says that when it is less than 2.5%, that it gets exempted from the purview of Section 8.
Section?
Section 8 of the NDPS Act, which
It will not be considered as
Then-
manufactured drugs.
there are two judgments in this aspect, my lord. One is from the Madhya Pradesh High Court and one is from the Allahabad High Court, where this plea has been accepted. But again, my lord, there are contradictory judgments from the Delhi High Court where this plea has been rejected.
And from our High Court?
Our High Court, my lord, there was a judgment long back in Shahabuddin's case where this honorable court rejected it, saying that because there is Section 80 of the NDPS Act, which says that it is not in derogation of the Drugs and Cosmetics Act, but in addition to it. So if the provisions of the NDPS Act can be brought in, then obviously the benefit of Drugs and Cosmetics Act will not apply. But in that case, that was a case where the person was found illegally transporting 347 bottles of codeine cosmetics. Here in this case, the distinction would be that this petitioner before your lordship, he is a license holder for selling and storing minor drugs. He has a license. So his case will not be applicable in the light of Shahabuddin's case because he already has a valid license. This aspect was also again rejected by the learned trial court. The problem which I am facing today, my lord, is that I have been able to get the judgments which are in my favor, but not the judgments which were against me because the internet was slow and I could not print those out. So, but that is the aspect which, in fact, my learned friend would also appreciate. Whatever your lordship will decide, will lay down the law and it will also have some implications, my lord, in other cases. So, if your lordship will kindly give me some time, I'll file a compilation in this regard, my lord.
Okay. Heard. Mr. S. Nawaz, learned counsel for the petitioners. Also heard Mr. B. Sharma, learned counsel for the learned additional public prosecutor. Learned counsel for the petitioner submits that in this case, learned counsel for the petitioner submits that in this case, the contraband seized is
Codeine phosphate.
50 bottles of codeine phosphate, weighing about 7 kgs. However, the content of codeine, what is
Content of codeine, it has been given as that has
no,
not been specified in the
what is the notification says?
notification, my lord, notification says that if it is less than 2.5%, then it is exempted from the purview of the NDPS Act.
As per which notification?
There is a notification, my lord, give the notification number, my lord. Notification is, I'll give the number, my lord. I have it written.
However, he submits that there is a notification issued by Union government which exempt the cough syrups containing less than 2.5% of total weight of
2.5% of codeine
2.5% of codeine in the
in the mixture.
where
In the cough syrup, if it is less than, if the codeine element is less than 2.5%, it is exempted.
क्या लिखा? From the purview of
The NTPC.
from the purview of the definition of manufactured drugs, and as such, his case is exempted from application of NDPS Act 1985 and would be governed by Drugs and Cosmetic Act 1940. Here is correct.
My lord.
Learned counsel for the petitioner, however, submits that he may be granted some time to produce a compilation of authorities on which he would be relying in this case. The prayer is allowed. How much time?
In a week's time.
Let this matter be listed on again on 20 March.
I'm deeply aware.
Item 2. Item number 2.
My lord, this matter may be taken up at 2, my lord. At second half, my lord. In the second half.
Yeah, 2 will take it.
Item 62.
Right, please, Lordship. Also in this last occasion, Lordship, regarding the service report, Lordship, regarding, in the respondent number 2.
My lord, here I informed the office, my lord, to receive the, my lord, instruction, but lordship may kindly place between 2 of their petition, my lord, post title, my lord. There are some mistake on their part, my lord. Perhaps that's why it does not.
Yes.
My lord, it is Sonaik PS case number 7/2025. But I have verified, my lord, it is from the, my lord, FIR, my lord. Page, my lord, 10. Page 10, my lord. 11%, page 11, my lord. It is 70/2025.
No, in the court's copy, some correction has been made.
My lord, that's why.
70.
But in our copy, my lord, it was 7. That's why perhaps there is some miscommunication.
No. Now we have to see whether notice has been served on respondent number 2. You have to intimate this.
My lord, I have already in the morning, my lord, I have clarified and I have want to take instruction, my lord, to the officer, my lord. 70/2025.
No, when will you inform this court?
My lord. Day after tomorrow, my lord.
Okay. Heard Miss R. Wrongme. Heard Miss R. Wrongme, learned counsel for the petitioner. Learned, also heard Mr. B. Sharma, learned additional public prosecutor, who submits that he may be allowed some time to inform this court regarding the fate of the notification, fate of the notice issued to respondent number 2. Considering the submission, the prayer is allowed. Let this case be listed again on 11th of March, day after tomorrow.
Item 63 and 64.
May it please your lordship. My lord,
May kindly come to page number 19, that is the FIR. 63 matter. My lord, I am appearing in 63. There are two matters, 63 and 64. I am appearing in 63.
64, so this is for the first time.
Yes, my
Oh.
lord. TD was called for, and I am told that the CD is there.
Okay, okay. You are appearing in that video.
63.
Yes.
My lord, the petitioner before you, your lordship happens to be the jailer of Kamrup Metro Central Jail at Lokhra. Was a jailer.
He is in jail now
He is in jail for last 31 days
as an accused.
as an accused.
Otherwise, also he used to be in jail.
Otherwise also he used to be in jail.
Okay.
Place remains the same, only status. Now, my lord, will kindly come to the FIR which your lordship will find at page number 19, 19. And I'll take your lordship to the operative part, which is at page 23. My lord is there at page 23.
Yes.
My lord, I'll read the FIR.
Yes.
The FIR is lodged by the superintendent of Central Jail. It says, I am to inform you that the police personnels, my lord will kindly take note of this. The allegation is against some police personnels. I am to inform you that police personnels, namely Khogen Bora, my lord will kindly take note of this name because this has a relevance. Police personnel, namely Khogen Bora and
Konkon Bora.
Konkon Bora, sorry, Konkon Bora, not Khogen Bora, sorry. Konkon Bora and constables such and such Devojit Das, Gauhati have been detailed for internal security purpose for this jail along with head warder, warders and police personnel for guarding and security purposes. The said police personnel, by taking undue advantage of their official duties within the jail premises, acted in violation of lawful direction and indulged in illicit activities. They allegedly asked convicted prisoners and under trial prisoners to pay money in exchange of providing better facilities. In cases where inmates or their victim failed to pay, they were threatened with torture and harassment inside the jail. By creating fear and issuing such threat, the police, my lord, kindly take note, by creating fear and issuing such threats, these are two, my lord, important words, my lord. The police personnel forcefully and illegally collected money. After receiving the said money, they facilitate the entry of prohibited articles into the jail premises for the accused persons. It is further submitted that the said police personnel have allegedly received illegal gratification. Police personnel received gratification from visitors and in support thereof printed copies of screenshots showing receipt of money through Google Pay is enclosed herewith. It is pertinent to mention here that on regular frisking of engaged head warder, warders and police personnel of 14th APBN, Kahilipara, Gauhati, for the duties from 2 a.m. to 5 a.m. on 1/2/2026, 19 small packets of suspected ganja recovered from the possession of Konkon Bora. From the possession of Konkon Bora, photographs of CD of video are enclosed. I therefore request you to please register a case against aforesaid Konkon Bora. So therefore, my lord, if I understand the FIR correctly, it implicates certain police officers, including Konkon Bora, from whose possession small quantity of ganja allegedly was recovered. So prima facie, the FIR does not contain any allegation against the jailer. Now, my lord, before I go to the other factual part, your lordship will kindly take note of the sections under which this particular case has been registered. My lord, if your lordship takes up the BNS for a moment, my lord, the first section is 250. 250.
Yes.
My lord, is there 250?
Yes.
Taking gift, etc., to screen an offender from punishment. And the maximum punishment is up to 7 years and the offense is bailable.
Yes.
Then section 199. My lord, is there? 199.
Yes.
Public servant disobeying direction under law. Punishment 2 years, bailable.
Yes.
Then it is read with, I'll come to my lord 308. Just before that, I'll deal with the bailable sections first. And read with 20B2 capital A, that is small quantity, which your lordship knows it is a bailable section, as held by our High Court and many other High Courts, my lord. Because the punishment is up to 1 year. So therefore, my lord, then now it brings us to section 308, my lord. The case, this particular case becomes non-bailable because of 3085. My lord, may kindly come to 308 of the BNS for a while.
Yes.
308 extortion. Whoever intentionally puts any person in fear of any injury to that person or to any other and thereby dishonestly induces the person so put in fear to deliver to any person any property or valuable security or anything signed or sealed which may be converted into a valuable security commits extortion. Putting somebody into fear. Now, my lord, will come to subsection 3 of section 380. Whoever, in order to the committing of extortion, puts any person in fear or attempt to put any person in fear of any injury shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. And the section is bailable. Now, 3085. For 3085 to come, my lord, I'll read 3085 because this is non-bailable. Whoever commits extortion by putting any person in fear of death or grievous hurt. My lord, I searched in vain any allegation, howsoever remote, which speaks of that any of these accused have put somebody into fear of death or grievous hurt. It simply says, I'll go by the letters, I'll go by the words of the FIR. It simply says, that is why, my lord, I said, by creating fear and issuing such threat. Therefore, my lord, my respectful submission first is that this case has been registered under 3085 just to somehow bring it into the purview of some non-bailable section. And therefore, my lord, 305, even the police personnel knows that 305 allegation is not even there prima facie. This is number 1 submission. Number 2, your lordship is rising, my lord.
Okay, we'll continue.
My lord.
At 2.
My lord.
Anything?
My lord, item number 17, which was mentioned in the morning, my lord. In that case, when your lordship is fixed it on 13, but can it be on 12, my lord? Some senior advocate will be
Item number?
17, my lord.
Item number 17 instead of 13, let it be on 12.
Yes, Sandeep,
But there is a small with regard to item number 61, court number 8, my lord. There is an interim order. It may be continued, my lord.
Interim order shall continue.
Blessed.
Yes.
So, my lord, what we have seen is that from the FIR, there is no allegation in the FIR against the present petitioner. Number 1. Number 2, the sections which are imputed in the FIR are all bailable and 308 subsection 5 is not attracted even remotely. And, my lord, on the factual part, my lord, because the recovery of the ganja as alleged in the FIR is from one Konkon Bora. If your lordship remembers, from one Konkon Bora. Now, my lord, will kindly take up my additional affidavit, my lord. Your lordship may kindly take up my additional affidavit, which is there. My lord, may kindly come to page number 52, 53. Page number 52. The vernacular is in 53. I'll take your lordship to 52. It is typed copy.
Yes.
Here is in.
Now you are under suspension.
I am under suspension. So therefore, my lord, no chance of, and even I am kept in Morigaon jail, not even in Kamrup jail. So therefore, there is no chance of any tampering with anything, my lord, of that sort.
Provided you are, you continue to remain in Morigaon jail.
Pardon, my lord?
That submission is valid only if you continue to remain in Morigaon jail.
No, my lord, because yes, the point which I'm trying to make is that even for any other purpose, my lord, because I cannot manipulate anything because I am already suspended and I am not in the vicinity of Kamrup Metro Jail. Coming to page number 52 for a while, my lord, your lordship will see that against this Konkon Bora, from whose possession this small quantity of ganja was recovered, or against whom the primary allegations were there, we issued a show cause notice to this Konkon Bora. You are hereby informed that prohibited substances was recovered from your possession during the routine check on 31/1/2026. You are hereby directed to show cause why matter should not be reported to higher authority and higher authority. You are directed to show cause. Now, my lord, this show cause notice precedes the FIR. It is not that after lodging of the FIR, in order to cover up something, this show cause notice was issued. This show cause notice was issued to Konkon Bora by the Superintendent of Central Jail, Gauhati, and the same was countersigned by the present petitioner, who is the jailer. And this precedes, my lord, the FIR in question. Because the FIR was lodged on 3rd of February and this show cause notice was given on 1st of February. Now, my lord, against this show cause notice, this Konkon Bora furnishes a reply which is at page number 54. He was in fact praying for condoning this incident. So this letter, page 54, is by Konkon Bora, and this letter is my lord will kindly come to page 55 because the remark is in page 55. This letter was in Assamese and the remark given by the present petitioner, your lordship will find page 55 left hand side, that's small in English. Apology may not be entertained in view of security aspect of this jail. Rather, he was taking up these issues very seriously. Now, my lord, this Konkon Bora, from whose possession who is an FIR name accused and for whose possession allegedly small quantity of ganja was recovered, has been granted bail by the learned court below at page 56. That is on 5/3/2026. Your lordship will see Konkon Bora.
Okay. Okay. Now what is your submission?
So, my lord, the prime accused is on bail. 31 days he has spent in custody. No.
Yes, Mr. Sharma.
Subject to what he says.
One more petitioner is.
308.
One more petitioner is before your lordship. So lordship may hear him first.
Who is there?
I am the constable, my lord, here. In the present case, my lord, there are three.
This case may be different.
My lord.
No, more or less same lordship.
Okay.
Now, lordship may kindly, item number 64, my lord, item number 6. Is 24 hours, my lord.
What is the allegation against you?
My lord, that's fine, my lord. I'm page 20, my lord.
Yes.
Page 20, my lord, the paragraph number 8, my lord. During the course of investigation, 19 packets of suspected ganja.
You are Konkan Bora.
No, my lord. I'm not. Concon Bora, my lord, already granted bail, my lord. We are on the same
Oh,
footing, my lord.
okay, okay.
And from his possession, my lord, the cannabis were seized, my lord. During the course of investigation, 19 packets of suspected ganja cannabis were recovered from the possession of accused Kankan Bora, which were seized as per on being produced by the complainant, establishing the involvement in offense under the NDPS Act. So he was granted bail by the court below, my lord, on completion of 29 days, my lord. Now here, my lord, both the petitioners are behind the
What is the accusation against you?
my lord, my allegation that will find my lord, paragraph 9, my lord. During investigation, it has been revealed that as per the direction of the
You are
accused-
Devajit Das.
Yes, madam. That is the allegation.
Okay.
That much, my lord. And my lord, the prime accused, my lord,
Then why your prayer was rejected by trial court?
my lord, it was not rejected. We have not approached the trial court.
Why?
My lord, as we can approach the high court, my lord, we have directly come to the high court.
No, but you can approach the trial court also.
That's true, but the law doesn't bind us, my lord.
But we can send you back to trial
My
court.
lord, after 31 days, my lord, he had got bail, my lord, on completion of 29 days, my lord. And I am behind the bar, my lord.
Yes, Mr. Sharma. Was the jailer?
Yes, Lordship, I'm sorry, Lordship, I will submit in respect of him first, if Lordship permits me.
Okay.
Lordship, may I consider his bail application subject to his involvement, Lordship, in view of his involvement, Lordship, and the co-accused has already been released on bail. So, Lordship, in my humble opinion, may
Okay.
consider his bail application.
I am obliged.
Then let us pass orders in.
Yes.
Heard Mr. N.J. Datta, item number 64. Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned counsel for the learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, Shri Devajit Das, who has been detained behind the bars since 4/2/2026. How many days?
33 days, no?
Within bracket for last 33 days in connection with Bashishta PS case number 47/2026 under section 250/199/308 within bracket 5/3 within bracket 5 of BNS read with section 20B2A of NDPS Act 1985. The gist of accusation in this case is that where is the FIR?
FIR, your lordship will find, my lord, at page, my lord,
And
page
that on
70.
3rd of February 2026. The superintendent of Central Jail Gauhati had lodged an FIR before the officer in charge of Bashishta police station, inter alia, alleging that the present petitioner as well as one other police personnel, namely Lance Naik, Kankan Bora, were found to take undue advantage of their official duty within the jail premises and were found to have acted in violation of lawful directions. It is alleged that they used to ask for money from the prisoners in exchange for providing better facilities. It was also alleged that they used to threaten the jail inmates of torture and harassment inside jail premises if they don't succumb to their demand. It is also alleged in the FIR that during regular frisking of the police personnel engaged in duty inside the jail premises, 19 small packets of suspected ganja were recovered from co-accused Konkon Bora. Learned counsel for the petitioner has submitted that the accusation against the present petitioner is that it is he who had procured ganja from outside and handed it over to Shri Konkon Bora. He, however, submits that the co-accused Konkon Bora has already been granted bail by the Court of Learned. Where is the bail order of
My
Konkon
lord,
Bora
please.
in your case?
In my case, I have not,
In your case.
Page 56, my lord. My lord, granted on 5/3/26, my lord. By additional session judge number 1, Kamrup Metro. Please speak.
Running page 56.
Yalika. Last line. Granted bail by the Court of Learning, Additional Session Judge number 1, Kamrup Metro, on 5/3/2026 in bail application number 83/2026. He submits that since the main accused from whose possession the contraband was recovered has already been granted bail, and since the quantity of contraband is of small quantity, he may be allowed to go on bail. On the other hand, learned additional public prosecutor, Mr. B. Sharma, submits that since the co-accused Konkon Bora has already been allowed to go on bail by the trial court, and since the present petitioner stands on more or less same footing,
And also investigation in respect of him has
Progressed.
progressed considerably.
and since the investigation, no, not since, and the investigation in respect of the present petitioner has progressed substantially, he leaves it on the court for considering the prayer for bail. Stop. I have considered the submissions made by learned counsel for both sides. Since the state has not agitated the bail granted to co-accused Konkon Bora by the trial court, and since the said co-accused stands on same footing as that of the present petitioner, as well as considering the period of detention of the present petitioner, this court is of considered opinion that if the present petitioner continues to cooperate in the investigation, his further custodial detention may not be necessary for fair completion of the investigation. Stop. Accordingly, the petitioner Shri Devajit Das is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of
Chief Judicial Magistrate, Kamrup Metro.
learned Chief Judicial Magistrate, Kamrup Metro, with following conditions, number 1 and number 2. Send back the case diary.
I am obliged, madam, deeply obliged.
Yes, what is your objection against?
Yes, here Lordship, what has happened, just a small recap Lordship. Here Lordship, one complaint was lodged before the CID by one person Lordship, that there are some illegal activities that are happening in the jail premises Lordship. That complaint was also forwarded to the Director of Vigilance and Anti-Corruption. Then Lordship, that complaint was forwarded to the Inspector General of Prisons, Assam Lordship, by the Superintendent of Police, CID. And after that, Lordship, inquiry was done. Now, Lordship, here that in the jail premises, Lordship, these two constables were there. They belong to Fort Assam APBN Rifles, Lordship. From one of the co-accused, Lordship, has already seen some contrabands were found. Thereafter, Lordship, he has already been released on bail, and in respect of him also, Lordship, the allegations are more or less the same. So I submitted that. Now, when the inquiry was done, Lordship, the warden, I'm the jailer, and also there are 3 other assistant jailers, Lordship. After inquiry, Lordship, it is in the case diary, the 3 assistant jailers, nothing has been found against them, Lordship. But against him, Lordship, sufficient materials have been found. First is, Lordship, when prisoners are given VIP treatment and some prisoners are not given the basic amenities, Lordship, and for exchange of that, money is demanded. Now, Lordship, the modus is, Lordship, the money is taken not by the jailer himself. It is taken by a grocery shop owner, Lordship, who happens to be just outside the premises of the jail. His 180 statement has been recorded. He has categorically stated, Lordship, that some persons, Lordship, had approached him and told him that the jailer had asked for depositing 40,000 rupees to his personal account. Then he got a telephone call from the jailer, Lordship, to
No, 40,000 by whom?
To be deposited in the grocer's account. The persons were directed by the jailer to deposit 40,000 rupees to the grocer accounts in lieu of the facilities and service that are given to one of the inmates of the jail.
Okay.
So those persons, Lordship, deposited 40,000 in the grocer's account, who is before your Lordship in his submitted his 183 statement, who has categorically stated that I was asked by the jailer to give my QR code so that 40,000 can be deposited. Later on, Lordship, the jailer comes to me and he takes away the money in cash. That is the categorical statement. I have flag mark. Next is, Lordship, what has happened? One of the accused person, Lordship, who was an inmate in the jail premises, efforts were done to contact him, Lordship, and he himself appeared before the police authorities, Lordship, and his statement was also recorded in 183, Lordship. But unfortunately, Lordship, his statement is not in the case diary. Since, Lordship, the last entry is of February, Lordship, 17th of February. The inmate's name is Kuldeep Das. He has made some statements regarding the jailer itself, Lordship, Kuldeep Das, because how he and his guardians were demanded money to give him certain facilities to stay in the jail by the jailer himself. So that is it. The IO notes is there, Lordship. I can show it. Next is, Lordship, in the order dated 8 to 26 passed by the SDJM, Lordship, after perusing of the case diary, Lordship, the learned court has categorically recorded, Lordship, the material suggests that a gang is involved consisting of government servants. Now, Lordship, inquiry is still going on, and it is alleged, Lordship, that prostitution is already also going on. There are contraband substances that are.
How prostitution?
Prostitution is going on inside the jail premises, Lordship.
Involving whom?
Involved that is under inquiry, Lordship. Investigation is still going on because the FIR.
No, assuming that whatever you are saying is true. Still, whether the case has been made out under section 308
Yes.
clause 5.
Yes.
How?
Lordship, money has been extorted, Lordship. The guardians.
No, but it remains bail 308 clause 3. His only contention is that
308
though for committing an offense under 3085, threat has to be of death or grievous injury.
Lordship,
Here there is there any material to show that that kind of threat was given?
the material Lordship investigation has to progress to a certain extent.
As after 33 days.
After 30 days, already one of the inmates have been interrogated. Lordship, his statement is not in the case diary. And Lordship will just assume, Lordship, the inmates who are staying in the jail, are they not put under threat, Lordship?
No assumption.
No,
You are I'm not saying that there is no material against them.
Lordship.
The contention of the petitioner counsel is that there might be material under for extortion, but of a lesser kind,
Lordship.
which is bailable.
No.
To deny him bail, the offense has to be under 308 clause 5.
Yes, 308.
So whether elements of that offense are there.
Lordship, for that purpose, then the statement of the Kuldeep Das, that has to be before your Lordship, which has already been recorded under 183.
Yes,
That is
produce
not in
it.
Yes, we'll produce. If Lordship kindly permits me to just read the note, Lordship. It has come to light that while he was in judicial custody.
183 statement.
Yes. His statement has been recorded. Now, after he was released, Lordship, his statement was recorded.
Because unless you can show that there is a threat of causing death or grievous hurt, it will not fall within 308 clause 5.
Lordship.
There may be some ingredients of extortion.
The extortion part is apparently there.
There may be extortion. Then they may ultimately be convicted also.
Yes.
But as on date, to deny them bail, there has to be some material.
Lordship.
For
Lordship, the materials only cannot be the applicability of a section. Lordship will have to see the larger picture involved here.
what larger picture?
Larger picture, Lordship, inquiry is still going on. Apparently, Lordship, there is a ruckus that is going on. There is a gang which is operating. Three assistant jailers have been, Lordship, has not come under the purview because no evidence has been found against him. He is the prime accused. Under him, all these personnel are collecting money. And Lordship, fear of threat or anything, Lordship, that is apparently there, Lordship. Because inmates, Lordship, when they are in jail, Lordship, they are put under.
No, I am just asking you a simple question.
Yes.
So, to hold somebody liable under 302,
Yes.
there has to be death.
Absolutely.
Similarly, to hold somebody liable under
Yes.
308 clause 5,
Lordship.
there has to be fear of death. Those ingredients are to be there.
Yes.
Otherwise, they will get benefit.
Yes.
And presently, you are unable to show anything.
Lordship, I have already submitted that the statement of one of the inmates who was there, Lordship.
Produce that
money,
statement.
yes, money was demanded from his family members and he paid money. That statement is not before.
No, mere payment of money may bring the case within section 308.
Correct. I agree with that, Lordship. But Lordship will see extortion part.
Okay, let us see. Let us see that. When will you produce?
As your Lordship directs.
My lord, I have a strong objection to this, my lord, because my lord will kindly appreciate this, my lord. 33 days has gone. Case diary was called for, your lordship will see when the notice was issued in this case.
No, suppose there is a threat which as contemplated under section 30.
My lord, it was incumbent on them to produce the case diary because this matter was fixed before your lordship. And it is not that it was fixed day before yesterday. Because just to deny bail and to keep him in custody for some more days on a mere basis of surmises assumption that somebody, whatever.
When can you produce?
As your Lordship directs.
Heard Mr. M. Bishwas, learned counsel for the petitioner.
My lord, just my lord.
No.
Then, my lord, just bear with me, that submission may be recorded, that in that statement, he has submitted that there will be some.
Please, heard Mr. M. Vishwas, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Shri Debakomal Borua, who has been detained behind the bars since 5/2/2026, within bracket for last 31 days, in connection with Vashishta PS case number 47/2026 under section 250/199/308 within bracket 5/3 within bracket 5 of BNSS 2023. Read with section 20B2A of the NDPS Act 1985. Stop. The main contention of the learned counsel for the petitioner is that all the offenses with which the petitioner has been charged in this case the petitioner is accused of committing in this case are bailable except offense under section 308 within bracket 5 of BNS. He further submits that neither in the FIR nor any other material has been shown by the prosecution side that for committing the offense of extortion, any person within bracket jail inmates were put in fear of death or of grievous hurt. Hence, he submits that even if the accusation made against the petitioner are assumed to be true, it only makes out a case under section 308 within bracket 3 of the BNS, which is a bailable offense.
Even in the ground of arrest, what he's submitting today is not there.
So, he further submits that in the meanwhile, two co-accused are namely Konkan Bora and today Devajit Das have already been granted bail. Stop. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner on the ground that the petitioner was the jailer of the central jail Gauhati, and materials are collected indicating involvement of a racket in committing the offenses which are alleged in the FIR. Stop. He further, when a pointed query was put to the learned additional public prosecutor as to what materials are there in the case diary to show the implication of the present petitioner in offense under section 308 within bracket 5 of the BNS, learned additional public prosecutor submits that the investigation is still going on, and one of the inmates who was released from jail has also, namely Kuldeep Das, has also been examined under section 183 of BNSS, and therefore his statement is relevant for consideration of the bail and for answering the query posed by this court. Stop. After considering the submissions of learned counsel for both sides, this court is inclined to go through the statement of the witness Kuldeep Das recorded under section 183 of BNSS by the court during the course of investigation. The learned public prosecutor is requested to produce the said statement when. When will you?
Lordship, I have a correction, Lordship. 183 was not recorded, 180.
180, it has to be in
It has
the,
to be there.
It is not here.
There is some foul play.
It is not here, Lordship. That's why I'm confused.
That is what precisely I was trying to
It is
point
not
out.
in the case diary. Statement of Kuldeep Das.
then how you can,
Because it is stated.
And there is no prior complaint.
then
Lordship,
then this is a wrong submission before the court.
yes, it is, I've taken it voluntarily, I'm giving it, Lordship. I'm not denying, Lordship. I made that submission, Lordship.
On what basis?
I stand corrected, Lordship, because there are two, one person by the name of Himanshu Borman, his 183 has been recorded. It was a mistake on my part. I thought it to be Kuldeep Das.
Oh, Himanshu's 183 is there on
Yes,
it.
yes, it is there.
He has not.
No, Kuldeep Das voluntarily appeared before the IO to record his statement, and which was recorded as per the IO's note. That is the there, but that statement is not in the case, the Lordship.
But it has to be there in,
Yes, it has
where,
to be
where
there,
it will be otherwise.
So it is supposed to be in the case diary, Lordship. It must be in the case diary, but it is not.
Then what is your submission?
Lordship will fix it tomorrow, Lordship. I'll speak to the IO about his statement, why it is not in the case diary.
Now suppose even if he produces a statement,
Lordship.
it cannot be relied upon
Absolutely.
because he can write anything. It is not required to be signed by the.
It is unsigned.
I'm granting bail to the petitioner, 30,000 same condition. I'll dictate the order in the chamber.
I'm so deeply obliged. I'm great.
इसमें changes होगा.
I will hand over the CD. Lordship.
Yes, you give me the case diary.
I'm deeply.
Item 2.
Wait, please, your worship.
Yes.
So this is a regular bail application. I'm in custody for the last 351 days. 19,296 numbers of tramadol tablets were found in the possession of 3 accused persons, my lord. And they were arrested on 28/1/2025. Now, 2 months after the recovery of this contraband from these 3 accused persons, I was arrested based on the statement of these accused persons that this contraband had been purchased from me, my lord. Your lordship will first kindly come to the FIR, my lord. Page 15, my lord. Page 15. Lordship has it. Lordship will find the paragraph number 1, 2, 3, fourth paragraph. During NACA checking, Lordship has that part. Below the name is my lord, during NACA checking, we observed a suspicious 4-wheeler vehicle bearing registration number so-and-so approaching our location. I signaled the vehicle to stop, but it initially attempted to flee. However, due to the strategic positioning of our vehicle, the police team, the vehicle was intercepted. I approached the vehicle and identified myself and found 3 individuals. So these persons were found, my lord. Ajay Sahani, Mujibur Rahman, and Musarraf Hussain. And next page, your lordship will find the description of the contraband, my lord. Page 16, 19,296 capsules, my lord. These are found to be tramadol, my lord. Now your lordship will kindly
What
come.
is the commercial quantity of
250 grams.
350?
250 grams.
250 grams.
This is commercial quantity, my lord. There is no dispute on that
Okay.
part. Now, this was on 28/1/2025. Now, your lordship will kindly come to page 19. Page 19, my lord. On 21/3/2025, that's almost 1 week shy of 2 weeks, my lord. 2 months, my lord. Grounds of arrest, my lord. The accused person has confessed his guilt During interrogation of FIR named accused disclosed the name of Amal Das as they bought the psychotropic substances from Amal Das. So it is on the basis of the statements of the co-accused persons that I was picked up and I was arrested, madam. So that is my first contention, my lord, that based only on the confessional statements of the co-accused, as well as my confessional statement, my lord, I have been arrested and detained. So in terms of Tufan Singh, my lord,
whether investigation is over?
investigation is over, my lord. Trial is going on, my lord.
Okay, apart from that,
That is one aspect, my lord, one point. And second point is, if your lordship will kindly come to page number 40, my lord, 40 and 41. These are the grounds of arrest, my lord, which were given to me as well as my wife, my lord, 47 and 48. Now here, my lord, as your lordship has seen, the accusation was the recovery of 19,296 tramadol tablets. Now that part is conspicuously missing. Only one thing is there at number 2, your lordship will see. During interrogation of FIR named accused, disclose the name of Onil Das. Now I do not know who Onil Das is, my lord.
who are you?
I am Amal Das. This, to be very fair, my lord, perhaps was a typographical error on their part. But whatever may be, my lord, on record, it is Onil Das. And that is the only thing which is there, that the FIR named accused disclosed the name of so-and-so as they bought psychotropic substances from Onil Das. What is the nature of the psychotropic substances? What was the quantity of the because quantity matters, my lord. Quantity will make it either a case of intermediate quantity or small quantity or commercial quantity. So that part is conspicuously missing. So that I at that point, neither me nor my wife knew what was the nature of the accusation, whether it was a case of small quantity, intermediate quantity, commercial quantity, what was the contraband? Nothing is there. Name itself is also wrong. So these are the 2 points, my lord, on which I am seeking bail, that I was arrested on the statement of co-accused and that is no substantial compliance of 47 and 48.
Yes, Mr.
As per TCI lordship, then that already the counsel for petitioner has already submitted lordship that the implications is dear lordship, the co-accused has implicated him, and the co-accused Musarraf, one of the person from whom the substance was seized, he is the employee of this person, and this person has a pharmacy, and from his pharmacy he used to supply all these materials, and he sent this. Lordship.
Now investigation has completed. During investigation, you got a lead that he used to supply. You have to collect evidence because this cannot be used as an evidence. Now, after completion of the investigation, apart from statement of co-accused, what other materials are there?
In investigation, also, the statement, co-accused statements is there also.
Apart from co-accused statement, there is nothing. Then Tufan Singh will come into play.
But for the purpose of investigation, it is.
No, now investigation is over. During investigation, you should have collected some other material by which may be utilized in trial. Now you don't have. This is my question. Do you have anything else apart from co-accused?
That nothing is there also. Only that his statement is there. One Musarraf statement is, and he himself has the immediate.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. P. S. Locker, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Amal Das, who has been detained behind the bars since 21/3/2025 within bracket for last 351 days in connection with special NDPS case number 172 within bracket N/2025 under section 61 within bracket 2/123 of BNS read with section 22 within bracket C/25/29 of the NDPS Act 1985. The aforesaid NDPS case is presently pending before the court of London. Which court?
Learned Special Judge Malot Knockout.
Learned Special Judge Nogam.
Additional Session Judge number 2 comes Special Judge number.
Learned Additional Session Judge number 2 comes Special Judge Nogam. The gist of accusation in this case is that where is the affair?
FR page 15, my lord.
That on 28/1/2025, one Partho Pratim Gogoi, SI of police, had lodged an FIR before the officer in charge of Nagaon police station regarding recovery of commercial quantity of tramadol tablets from three accused persons who were occupant of a vehicle bearing registration number AS01HC1810 stop. The name of the persons from whom the commercial quantity of contraband was seized are number 1 Ajay Sahani, number 2 Mujibur Rahman, number 3 Musharraf Hussain. Learned counsel for the petitioner, Mr. S. Nawaz, learned counsel for the petitioner, has submitted that though the petitioner was apprehended on
21/3/2025.
on 21
3/2025.
3/2025 on the ground that it is he who had supplied the contraband to the persons from whom it was recovered, however, he submits that in the notice under section 47 of BNSS, as well as in notice under section 48 of BNSS, which were served on the petitioner as well as his wife, no accusation against the present petitioner has been made. Rather, it was mentioned in point number 3 of the said notice that the FIR named accused disclosed name of one Anil Das, from whom they have brought psychotropic substance. Stop. Learned counsel for the petitioner further submits that apart from the statement of co-accused, there is no material to implicate the present petitioner, though charge sheet has also been laid against the petitioner along with the other co-accused. What is the case, Tufan Singh's citation?
2021 4 SSC 1.
1.
2021 4 SSC page 1.
Stop. क्या लिखा? However, as there is no admissible evidence against the present petitioner is on record, he is entitled to get bail in this case. On the other hand, Mr. P.S. Lakar, London additional public prosecutor, has fairly submitted that apart from the statement of co-accused, there is no other material in the record against the present petitioner. Stop. I have gone through the materials available on record and have considered the submissions made by learned counsel for both sides. It is apparent No, it is no longer res integra that no longer res integra after the judgment of the apex court in the case of Tufan Singh versus State of Tamil Nadu, reported in 2021 4 SCC 1, that a statement of the co-accused cannot be used as evidence against another co-accused in a trial involving offense under NDPS Act 1985. In the instant case, apparently, even after getting lead during the investigation that it was the present petitioner lead during investigation from the statement recorded, statement of co-accused recorded during investigation, that it was the present petitioner who supplied the contraband to the arrested accused persons from whose possession the contraband was recovered. No evidence could be collected. No admissible evidence could be collected by the investigating officer during the course of investigation. Stop. As such, in view of the judgment of the apex court in the case of Tufan Singh versus State of Tamil Nadu within bracket Supra, there is no admissible evidence against the present petitioner on record to implicate him for the offenses alleged in this case. Stop. In that view, the embargo of Section 37 of the NDPS Act is also not applicable to the present petitioner. Stop. Moreover, if we peruse the notice under Section 47 of BNSS, which is served upon the petitioner, as well as notice under Section 48 of BNS, which was served on the wife of the petitioner, it also appears that therein it has been mentioned that the contraband which was recovered in this case was brought from one Anil Das. Stop. Though the learned counsel for the petitioner has fairly submitted that this might be a typographical mistake, however, there is no material on record even to come to the conclusion that same is a typographical mistake. Under such circumstances, the aforementioned above named petitioner is entitled to get bail in this case. Accordingly, Shri Amaldas, his grant, is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned
Additional session judge
additional session judge
number two.
number 2, Kumar Nagaon, with following conditions. Conditions, NDPS bail conditions. This bail application is accordingly discussed.
I'm deep privileged.
I have handed over the CD. Lordship may kindly reflect in the order that I have submitted that his 180 statement has been recorded, but it is not in the case study. It is not in the case study. So that may be clearly reflected. Any possible,
No,
Lordship?
whatever I have dictated in the
Yes,
open
yes.
court, that I will cancel.
Yes, yes,
I'll pass a new order,
Lordship.
but I am granting bail to
Yes,
them.
yes. And if Lordship can grant.
No,
a-
I'll reflect your submission.
Yes,
That 180 statement, you have been informed by IO that he has recorded 180
There's a
statement.
note, Lordship.
But that is not available in the
Yes.
case diary.
There is a note of the IO Lordship that 180 has been recorded, but it is not in the case diary.
Okay. okay.
And Lordship, if I may just submit Lordship, Lordship can grant bail. Lordship can call for the IO to be personally present before Lordship to explain why that statement is not in the case diary.
I'll think it over. I'll pass something so that these things are not
So Lordship,
repeated. Instead of calling,
Lordship, I'm praying and I'm insisting, Lordship, that the IO may be called over.
okay, I'll reflect your
Because
submission.
these things, Lordship, are not good for our side also. Lordship.
Yes, I'll reflect your submission, but what I will do, you have to wait for that.
Yes, yes, absolutely.
But I will certainly pass some observation.
Yes, Lordship.
Item 39.
Nine. Yes.
My lord, order dated 18/2, my lord. Here, my lord, default bail is being sought for. My lord, because of an authority of our High Court, my lord, with all respect, my lord. If it is in the prosecuting inspector's office, thus it is submitted, that won't do, my lord. It is the date on which it is placed before FF is placed before the learned magistrate, my lord. That would be the date of filing the FF, my lord. That report was sought for, my lord. And the 90 day, no? 90-day period expires on
Whether report is there.
1/2/26, my lord. Report.
Is there?
What is the case?
My lord, is POSCO, my lord. And the
9-2. However,
oblige, my lord.
Item 40.
Only point in this case, charge sheet in the meantime, charge sheet file, my lord. I think it has come. Yes.
item number?
14, my, 1-4.
No, 40.
Oh, sorry, 40.
4-1.
4-1.
40.
4-0. Hanif Ali.
Yes.
In this case, my lord, the recovery was about 720 capsules containing 90 strips. Now, only, my lord, here case is, my lord, 36. To our information, 36 not come. Subsequently, we got it, we could not annex it, my lord. So, your lordship record is here. And second question on the charge sheet, whether it is commercial or B. To our calculation, whether it comes to B, my.
How?
Tamadol, my lord, actually, they have calculated it from Google sectors and they have, my lord, they have found it below 250 grams is the commercial Tamadol. 250 grams.
Yes.
It
What is the
comes-
total weight of capsule?
Total
weight of capsules which are seized.
So that whether it is there or not, what your lordship may say, but if that is there, my lord, I have nothing to say. So far commercial part is concerned. Thereafter, if it is a certain amount of commercial, then my lord, question of 36 only. This is one the case before. My lord. The 36 to be.
How 36-1 was violated?
Madam, mandatory is what they are not 36 to law.
Scan copy of the CD is there.
Yeah.
Case diary is there.
We got a certificate of my lord, 36.
Mr. Sharma, have you gone through whether
My lord, I have gone for regarding 47-40 notice, that is clear, my lord.
whether
Take it up
36
plea,
has
my lord, I have to go through.
whether they have taken plea in the bail application?
My lord, not taken.
48 we have taken.
36.
We got 36 BN. Yeah.
No, you have to, unless you take this plea, you will
My
not
lord.
get benefit.
No, subsequent legal point, my lord, legal
No,
point.
no, it is a question of fact.
No, that is a question of law, my lord.
36 is a question of law,
Yes.
dependent on a question of fact, whether it was,
Now, the record will show, my lord. Record itself will show. If 36 notice is there before lordship, your lordship will see whether it is complied or not, my lord. We say signature is not there, my lord. Witness signature is must, my lord. One of the witness must, my lord. It is must. So that notice itself is before lordship. If the comply, I have nothing to say, my lord. This is a question of law, my lord. It is not a question of fact.
yes, Mr.
Lordship,
Chair.
may kindly pay last order, my lord. Last order, my lord.
First page 36, my lord, section 36 missing.
Last order, my lord.
No, you cannot take court to surprise.
No, my lord. I am saying.
What would be your plea during hearing?
No,
That has to be
my
pleaded
plea-
in the
when I got
petition.
Certificate copy, my lord, initially.
No, no.
There was instruction that 47, 48 is not there. We got the certificate.
Neither can you take the other side by surprise.
No,
What would be your plea during the, for seeking bail? It has to be pleaded so that they come
My lord,
prepared.
my
no,
lord.
legal point I can take anytime, my lord. Law point, my lord. Law point not necessarily, but factual part I cannot change. My lord, factual law part I can take. It is there before your lordship, before them also, my lord. That is a question of law, my lord. Just have a look to page section 36, my lord. What it says, and if not is satisfied, I have nothing to say, my lord.
No, no. Whether 36 has been complied or not,
Yes.
it is a question of fact. The necessity of complying with 36 is a legal question.
So necessity of your lordship is to see it, my lord. Now, because it has come subsequently, I came to know, my lord. These people are.
No, you have to take that plea.
My lord.
Take that plea in your bail application.
Then let us go, my lord, we will take it, my lord. We'll take it, my lord.
Yes, Mr. Sharma.
Yes, with the liberty to file again, my lord.
Heard Mr. H.R.A. Chaudhary. How much tramadol was recovered here?
That is, my lord.
Numbers are there, my lord, 722 number.
722.
Then you can come prepared.
Well.
Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. I. M. Ali, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned counsel for the learned senior counsel for the petitioner has submitted that though by order dated 22/2026, the record of the trial courts were called for the purpose of verifying as to whether notice under section 48 and 47 and 48 of BNSS were duly served. However, he submits that even the compliance of section 36 of the BNSS is not there. Learned senior counsel further submits that since non-compliance or compliance of mandatory provision of law is a question of law, it can be taken at any point of time. However, when this court insisted that whether any such pleading is there regarding non-compliance of section 36 in the bail application, learned senior counsel sought leave of this court to withdraw, allow the petitioner to withdraw this instant bail application with liberty to file afresh, taking the said plea therein. The prayer is allowed. This bail application is dismissed on withdrawal with the liberty sought for granted.
Obliged to us. My lord, before you also, my lord, I have item 38, my lord.
38, my lord, already another matter out of the same, it was listed in 23, I think court number 20,
30, date 30.
court number 23, my lord. So that case
38,
was fixed on
there was a mention.
38, my lord.
Okay, okay.
So another out of the same FIR, my lord, same another petition was pending today, it was in court number 23.
Yes.
Item
More.
number, my lord, 42. In that case, it is fixed on 38, my lord.
30.
30.
Then let us also fix this.
Fix that with interim continue, by
Okay.
interim also there, my lord, in both the cases.
Heard Mr. H.R.A. Chaudhary,
Item
Learned
38.
Senior Counsel assisted by Ms. S. Nazneen, Learned Counsel for the petitioner, who also had Mr. B. Sharma, Learned Additional Public Prosecutor. It is submitted by Learned Counsel for the Learned Senior Counsel for the petitioner that out of the same FIR, another criminal petition,
Yes.
that
It
is
is
criminal petition number
138/26.
138/2026 is listed
In court number 23, item number 42.
before a coordinate bench of this court on 30/3/2020.
No, today it was in the list.
Next, it is listed on 30/3/2026. He therefore submits that this matter may also be listed along with the same. Stop. The prayer is allowed. Let this criminal petition be listed along with criminal petition number
138/26.
2026 on 30/3/2026.
Interim.
The interim order shall continue till next date.
Bail hearing, item 18 of court number 16.
Yes, appeared and it can record it.
In this way, this can be heard Mr. B. Sinha, Learned Counsel for the petitioner, also heard Mr. B. Sharma, Learned Additional Public Prosecutor, who submits that the petitioner, namely, what is the name?
Abdul Rauf Ahmed.
Petitioner, namely, Abdul Rauf Ahmed, who was granted interim anticipatory bail by this court on 26/9/2025, has appeared before the investigating officer of
Tarabari PS.
Tarabari PS case number
27/25.
27/2025, and his statement has been recorded. Stop. Since the petitioner has complied with the direction of this court and has cooperated in the investigation, the interim anticipatory bail granted to him on 26/9/2025 is hereby made absolute, subject to the absolute with condition number 1 and 2 attached to the said order remaining intact.
Item 44 of court number 8.
Your lordship, may be pleased to.
It is there.
No, your lordship. CD has not been received.
Heard Miss, what is your name?
B. Chauhan.
Heard Miss B. Chauhan, Learned Counsel for the applicant. Also heard Mr.
Your lordship, interim may be extended.
What is the matter?
Lordship,
It is a very old case.
20.
When you got we'll make it absolute, Mr. Sharma. More than 1 year this matter be pending. You have appeared before the IO,
Your lordship.
yes or no?
Yes, your lordship.
Learned counsel for last line के लिख ले. Stop. Learned additional public prosecutor has submitted that though the case diary was called for, however, same has not yet been received. On the other hand, Ms. B. Chauhan, learned B or S?
B. Chauhan.
B. Chauhan, learned counsel for the petitioner, submits that the petitioner was granted interim bail by this court on 20/2/2025, and in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. Stop. I have considered the submissions made by learned counsel for both sides. It appears from record that the petitioner was granted interim anticipatory bail more than a year ago on 20/2/2025. However, the prosecution side has not been able to produce the case diary. Under such circumstances, no further indulgence can be granted to the prosecution side. Considering the submissions made by learned counsel for the petitioner that the petitioner is cooperating in the investigation, the interim anticipatory bail granted to the petitioner, namely, what is your name?
Mahendra Chauhan.
Mahindra Chauhan is namely Mahindra Chauhan on 20/2/2025 is hereby made absolute, subject to the condition that he shall continue to cooperate in the investigation and shall not directly or indirectly make any promise, threat, or undue influence to any witness or any person who is acquainted with the facts of the case, so as to dissuade such person from disclosing such facts before the investigating officer or before the court. With above observation, this anticipatory bail application is hereby disposed of.
Item 46 to 49.
May I please ask? Let all these four bail application, why not have arisen out of the same FIR. One is AB, that is item number 46.
Yes, Mr. Lawker.
Before starting my friend's lordship, I would like to mention lordship that lordship here in this case lordship we have received a CD, but injury report that is not received lordship. Medical report is not available. I have talked
What
with
is the case?
My
that
lord,
lordship.
on the last day, same submission was given because the FIR was lodged by the police itself. In fact, there was no injury. That is why that injury report has not come. On the last occasion also, they took time, lordship. We are behind the bar in three cases, lordship, in 47, 48 and
Injury
49.
report of police. Who is it?
I talked with the IO lordship, and as per his statement lordship, he has stated as lordship that the concerned doctor is on leave, so he may join within 2-3 days. So after this lordship, he requested me the
So within a week, you can
lordship.
let them to get.
The last chance may be
My
given.
lord, in fact, if your lordship go to the FIR, your lordship will find that they are.
No, I am giving one last chance. I am specifically reflecting it. He heard Mr. M. Khan, learned counsel for the petitioner in all four cases. Also heard Mr. P.S. Lockhart, learned additional public prosecutor, who submits that though the case diary is available, however, the injury report is not there, and he has been informed by the investigating officer over telephone that as the concerned doctor is on leave within a day or two, he may be able to collect the injury report after the said doctor joins his duty. On the other hand, Mr. M. Khan, learned counsel for the petitioner, submits that on the last occasion also same plea was taken. And in fact, no injury has been sustained by any police officer. Therefore, the investigating officer is unable to produce any injury report. Considering the submissions made by learned counsel for both sides, this court is inclined to give one last chance to the prosecution side to produce the injury report in connection with the aforesaid cases. Let the case diary be retained till next date. Let this case be fixed for receipt of injury report on
Monday next, Lordship, 16.
16, on 16/9,
My lord,
16/3.
my lord, one submission, lordship. Three cases are BA and one case is AB. AB is in the top. May I pray, lordship, BA number 390/2026 may be the top. in the-
On next date, you may
My lord, otherwise this AB, bail application will be listed in the column of AB, here in this case, lordship as well. So I am praying, lordship, BA number 390/2026 may be in the top of my series.
no, how it matters. It is taken up later.
No,
You fear that it may not reach.
yes,
That
that's
is
the possibility, lordship.
Then you make a submission for taking
Bail
it.
matters, it's Lordship. Normally, bail matters.
Bail matter, normally, lordship, BA matters coming.
Na,
into the-
BA hoy jaye.
If your lordship pass out,
No,
it will be,
taken up together. That is,
no, your lordship will take up this matter together. Only my prayer, it may be lordship in the series, BA number 390 may be in the top. In that circumstances, it will come in the BA column.
the above cases should be listed together on the next date with bail application number 390/2026 be shown as the lead case.
Yes.
Item 66, no supplementary.
May I please, Lordship? Lordship, this is POCSO matter, your
Item?
Lordship. I have taken step on 20/2/2011.
And 183 statement and charge sheet also not available in the report, madam. Only some orders are there, madam.
Okay. Heard, Mr. What is your name? A. Islam.
Islam.
A. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 7/3/2026, it appears that service report in respect of notice issued to respondent number 2 has not been received. Learned additional public prosecutor is requested to get information about the fate of notice issued to respondent number 2 to the officer in charge of the concerned police station and let this court know about the same on the next date fixed. Stop. It also appears that the scanned copy of the connected case diary has not been received in this case.
My lord, only some orders are there, madam. 183 statement and charge sheet also not available.
The registry is directed to send fresh requisition for sending the scanned copy of the case diary of Bilasipara PS case number 327/2025 before the next date fixed, so as to reach this court before the next date fixed. Let this matter be listed on 18th of
18th.
March.
Order item 50.
None has appeared
Item 50.
for the petitioner on call. List this matter again on 11th of March.
Item 51.
Same.
None appear.
Item 53.
Please, your lordship. Your lordship, this matter has come up for order since, even though we have taken steps on respondent number 2, but till date, none has appeared on behalf of the respondent number 2. As such, we may be allowed to take fresh steps.
Whether it was served on respondent number 2 or not.
Your lordship, may I peruse office note dated 6/1/2026.
What it says?
Lordship, it's there.
6/1/2026. What it says? Have you gone through it?
It says that it has been returned back.
No, it says that it has been received by respondent number 2.
Yes. Sorry, lordship.
Heard, miss, what is your name?
M. Borua.
M.
M. Borua.
M. Barua, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 6/1/2026, it appears that notice to respondent number 2 has returned after service. Miscellaneous file আছে নাকি? Service. After service. As such, I have gone through the report of the process server, which shows that notice to respondent number 2 has been served on her, and she has put her signatures on the said notice in acknowledgement of due service. As such, the notice is deemed to be duly served on respondent number 2. Stop. Let the scanned copy of the records of PRC case number 525/2024 be called for from the Court of Learned, Chief Judicial Magistrate Karimganj. let this case be listed after receipt of the aforesaid record on 30th of March.
Much obliged.
Item 54.
May it please your lordship, this IA is for suspension of sentence, your lordship. Conviction is under section 27 of Arms Act and read with section 504, part 2 of IPC, your lordship, and for 7 years.
For 7 years.
Yes, your lordship. Lordship, the informant is the wife of the appellant.
Wife of the appellant.
Yes, your lordship. Your lordship will come to page 18 of the appeal, your lordship. The FIR is annexed there.
Putul. Appeal. You are opposing, Mr. Sakya?
No,
Are you opposing?
I'm not opposing.
Then we'll the appeal is admitted.
My lord.
Appeal is admitted.
Yes, your lordship. PCR was also called for. Scan copies are available.
Then we'll suspend this sentence.
My lord.
Mr. Sharma.
My lord. From the part of the state, my lord, we will have to, my lord, oppose and court below has rightly passed their judgment, my lord.
When your husband,
Yes, your
My
lordship.
when wife is not opposing.
My lord,
I'm the wife.
is the wife, my lord. And 7 years conviction was rightly passed by the court below, my lord.
What is your submission?
Your lordship, if your lordship kindly just has a look at the FIR and the deposition of the wife, your lordship. Your lordship will see the glaring contradiction.
After filing the, my lord, FIR, she said that it was done due to a misunderstanding. Prior to the, she wants to
Okay.
point out that, my lord.
Okay, heard. In IA Likhebo, heard Miss M.K. Brown, learned counsel for the applicant. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. P. Soikia, appearing for the respondent number 2. This application under section 430 within bracket 1 of BNSS 2023 has been filed by the applicant, namely John Kang Keo, alias John Kang Keo, praying for suspension of the execution of sentence imposed on him by the judgment dated 17/6/2025 as well as order dated 19/6/2025 passed by the Court of Learned Sessions Judge Tinsukia in sessions case number 60 within bracket capital CH/2023, and also play. Where are you now? Behind the bars?
Yes, your lordship.
And also prayed for allowing the petitioner applicant to remain on bail during the pendency of the connected appeal. Learned counsel for the applicant has submitted that the applicant has impugned the aforesaid judgment and order by preferring the connected criminal appeal number 342/2025, which has already been admitted for hearing. And at what stage it is pending appeal?
Your lordship, the TCR was called for.
Is already admitted for hearing. She further submits that in the connected appeal, there is a probability of getting favorable orders by the present applicant, as there are inherent contradictions in the statement of the witnesses vis-a-vis the statement made in the FIR. And anything else?
No, your lordship, that's it.
Stop. On the other hand, no, she further submits that the informant and the victim in this case is the applicant's own wife, who does not have any objection to his getting and for objection regarding allowing of the prayer made by the applicant. On the other hand, Mr. P. Saikya, learned counsel for the respondent number 2, submits that he does not have any objection if the execution of sentence imposed on the applicant is suspended during the pendency of the connected appeal, and he is allowed to go on bail. Mr. Sharma, what is your stand?
My submission is that, my lord, there is no chance of acquittal. Only in the exceptional circumstances, my lord, Lordship may suspend the conviction period, my lord. Here, PW2, my lord. PW2 here, she was also there in the at that time of the incident, my lord. Lordship may kindly page 23, my lord. Page 23 for a moment, my lord.
Yes, page 23 of the
Page petition, my lord, there, petition, my lord. Appeal memo, my lord.
yes.
My lord, my residence is situated near the veterinary quarter. On that day, about 12 noon, I, along with the complainant and one Basanti Borgoy, were in the veterinary quarter campus. Then the accused came and fired from a gun towards his wife, but the bullet hit the ground. Thereafter, we returned to our home. I do not know why he fired on that way, my lord.
Conviction is under what provision?
Conviction is, my lord, two, my lord.
506.
And one is 506 part 2 and one is 27 arms.
Learned Galika lastly.
In both the, my lord, the 7 years conviction.
On the other hand, learned additional public prosecutor has objected to grant of any suspension of the sentence imposed on the applicant during the pendency of the connected appeal. He submits that it is very unlikely that the applicant would get any favorable order in the connected appeal, as the independent witnesses have also supported the prosecution story. And this is not a exceptional case where the powers of this court may be exercised under section 430 within bracket 1 of the BNSA system. I have considered the submissions made by learned counsel for both sides. In this case, it appears that the applicant was convicted under section 506 part 2 of the IPC, as well as under section 27 of the Arms Act 1959, and was sentenced to undergo rigorous imprisonment for 7 years, as well as to pay a fine of rupees 10,000 with default stipulation. under you are convicted under two sections.
My
of-
lord, two section, my lord. 506 is one part, my lord.
506, Part 2, and Section 27 of Arms Act.
And was also sentenced for in 506, what was the punishment?
7 years.
Seven.
Same
My lord,
punishment.
Same punishment, my lord. And
Also punished,
fine also.
also sentenced in a similar way for offense under section 506, part 2 of the Indian Penal Code. Stop. It also appears that the connected appeal has already been admitted, and same is in the said appeal, the trial court records have been received, and as such, same is ready for hearing. Considering the fact that the sentence imposed on the applicant is for a period of 7 years only, and it is very unlikely, considering the huge pendency of criminal appeal before this court, that the connected appeal may be heard expeditiously. Hence, if in the event the applicant gets a favorable order in the connected appeal, he would be highly prejudiced if the sentence imposed on him by the impugn order is not allowed to continue. More so, the fact that the victim / the informant, who is the wife of the present applicant, has not opposed to the prayer for suspension of sentence. Stop. In view of above discussions, the applicant, namely so-and-so Namdena, is for the reasons stated herein above, the prayer made by the applicant in the instant application for suspension of the execution of sentence imposed on him by the impugned judgment and award is allowed. The said execution of the judgment on order which has been impugned in the connected appeal shall remain stayed till the pendency of the connected criminal appeal number 342/2025. Stop. The applicant is also allowed to go on bail of rupees 30,000 subject to the satisfaction of learned Sessions Judge Lakhimpur, Sessions Judge Tinsukia, with a condition that in the event of dismissal of the connected criminal appeal, the applicant shall surrender before the trial court to serve out the remaining part of his sentence. With above observation, this interlocutory application is disposed of. In main appeal, all sides are present. The Records of the trial court have been received. Whether paper book would be necessary? No.
No, your lordship, I've already annexed the depositions.
Release this matter for hearing after 8 weeks on a date to be fixed by registry.
Much obliged.
Item 55.
Yes, your lordship. Your lordship, in item number 53, there is an interim order. It may continue.
What interim? No, what interim? So,
Stay order one.
Stay order. In item number 53.
yes, what was the matter?
Lordship, it's related to, so it's, your lordship, it's a criminal petition for quashing of the order dated, impugn order dated.
Okay. Item 53 may.
53 already order. passed.
53, the interim order shall continue till next day. In item number 53.
Much obliged.
May I please your lordship? My lord, this petition we have
Well,
filed
item
for
number?
quashing of the
55.
of the charge sheet and the charge sheet, my lord. Whatever, my lord, the one Jewel Das, who was a friend of the informant, requested him to arrange some loan so that she can start a restaurant. And against the gold, she wanted to offer as security. And accordingly, this say the Jewel Das main accused, my lord, he took away the entire jewelry and took a loan from the bank by depositing the gold in his name. And out of 15 lakhs, loan was paid to him and 10 lakhs was paid to the informant. Said that only 10 lakhs has been granted. And it was also informed that in every month you deposit the monthly EMI so that he can get relief from the entire loan. So the lady informant was a very close friend of the main accused, who used to pay the amount regularly. And when the EMI was over, she requested the friend, brother, you return my gold now. Now, when my gold was not returned, she inquired to the bank and came to know loan was granted in the name of the friend whom she trusted as a good friend of family. And after that, he has withdrawn the entire gold and no EMI was also not deposited by him because he used to collect the EMI every month.
My lord, today is only for orders column, my lord. Whether
I-
service is complete or not, my lord.
And
that
let
is-
me complete 1 minute. So, my lord, this is the story. Now, my lord, what happened? After withdrawing the entire gold, he has sold it to me. That it is my gold. Kindly, I want to dispose it because I have to give up the loan amount of the bank. So, my lord, I have purchased it. And now case has been charged at 420 against the main accused Jewel Das, who has did all this mischief and also implicated me as a co-accused. Whether 420 lies against me, my lord. That's why I have come before the lordship, challenging the charge sheet, my lord. And notice was issued to respondent number 2, but my lord, it has been not served, I think, probably. No office note is not there. So my only prayer is that I pray for interim protection, my lord.
When is the next date fixed?
Beg your pardon.
When is the next date fixed?
Negative.
When is the
Next
next date?
date, I cannot say, man, at the moment.
That
I
is
have
it.
not contacted.
That is very relevant if you want to get interim.
I cannot, without knowing, man, I cannot say.
So I cannot grant interim now.
I leave it to your lordship, my lord. But it is a fact that I have not played any role. No 420 ingredient 420 cannot come against me. And she has got no allegation against
No,
me.
you take fresh steps
My
by,
lord.
No, I think wait for service report. I have seen.
have you taken steps?
Yes, yes.
When?
I have taken one immediately after this notice was issued by the Honorable Court.
No, you take steps by speed post.
My lord.
Again, speed
Again.
post.
Then we can see the track
My
consignment.
lord, that is also.
Heard Mr. S.C. Bishwas. learned counsel for the petitioner. On perusal of the office note dated 6/3/2026, it appears that the service report in respect of notice issued to
Well,
respondent.
next day, the 2nd May, I got it just now.
Okay,
from like
then we will be fixing our case before that.
Before, my lord, before that.
Before that. क्या लिखा? Notice issued to respondent number 2 has not been received. Stop. The petitioner is therefore directed to take fresh steps for issuance of notice on respondent number 2 by speed post within 7 days from the date of this order, returnable on 30th of March. No. Okay, on 30 March. 30 March. List accordingly.
Item 56.
May it please, my lords. My lords. On the last occasion, the CD as directed was received, and as per directions of this court, it was retained for consideration of my interim prayer for a stay. This is, my lords, a crossing petition I filed for an FIR which was registered against me under section 126 BNS, 296, 351 to Red with 35 of BNS, my lords. My lords, may kindly peruse the case.
What is
that-
the status?
My lord, the investigation is still under progress. Now, my lord,
What do you want to stay?
the further investigation, my lord.
Why?
Because, my lords, I have been, there is no case against me, my lords.
Then it will be revealed in investigation.
My lords, my lords, I am a student. my lords.
Are you on bail?
I have not been arrested, my lords.
Okay.
My lords, because except one, most of these are bailable offences, my lord. The only case is that this FIR was an outcome of seeking vengeance, because the applicant herein before, my lords, is the brother of an advocate who had gone to the police station, district police
No,
station on that
but-
date to pursue the case against registered against the informant in this present case, my lords. And when that informant was seen in the police station, he was not arrested. The counsel here, along with her colleague, had recorded a video, and then he started giving verbal abuses, because of which the informant's sister, the advocate, lodged an FIR with the district police station.
No,
However, that
if
was
CD is
registered.
there,
CD
if,
Let me
if
see.
CD is there,
My lords,
this
may
has to
kindly
be
consider-
finally disposed of, no interim.
My lords, may kindly consider it, because I'm a student and this case is hanging over me. I'm an aspirant for civil services, and because of this, my lords,
Therefore, it would be in your interest to finally get it disposed.
my lord, the only issue is that the service report has not returned. That's why it has come for orders. And my
Then
lords,
you take steps for the
I had taken steps way back on 7th of January, my lords, by speed post.
7th of January.
Yes, my lords.
Then we'll ask the registry to place the track consignment report. If it reflects that it has been served, we'll drop resumption.
Yes, my lords, that can be done. My lords, until the next day, at least the investigation will be stayed.
Also, yes, arrested, also, why this?
Investigation stay is not a good
And who
option.
witnessed it?
If the FIR indicates rightly or wrongly some
My lords,
offences.
these offences are not made out, my lord. That is the case. If my lords kindly peruses the FIR for my satisfaction, my lord.
Okay.
This is on purely vague allegations, my lord, at page 24. The informant here, my lord, is an accused in another FIR which I have also annexed with this petition, my lords.
No, those
Page-
things.
Yes, my lords, only the FIR, my lords, page 24.
Yes.
If I may kindly read.
Yes.
I, Mafiz Ahmed, son of so-and-so, would like to bring to your kind attention an incident that occurred on 1/12/2025 at around 5:35 PM. On the said date, after meeting the officer in charge of Dispur police station for a personal matter, I was leaving the premises when a lady advocate along with Mr. Tariq Chaudhary, he is the petitioner here, my lords, and Miss Tokma Mazumdar of house number so-and-so began recording a video of me without my consent. Upon objecting to this unauthorized videography, the individuals in question started quarreling with me. They misbehaved in public, causing a disturbance, and further threatened me with dire consequences. This incident took place in a public area which caused both mental distress and inconvenience to me. I request you to kindly take appropriate legal action against the individuals involved in this incident in accordance with law. My lords, from a perusal of this, my lord, these offences are not prima facie made out, my lords. The ingredients itself are missing. To consider-
And Under what provision it was?
My lords, 126(2).
What is 126(2)?
126(2) is, my lord, criminal intimidation, which says that I have prevented him from moving towards a direction in which he was legally entitled to do. There is no statement to that effect that I have prevented him from going anywhere, my lords. 296, my lords, obscene acts and songs, my lords. There's nothing to that effect in the FIR, my lords, that I have made such utterances. And my lords, 351 is again criminal intimidation, my lords. The ingredients must be fulfilled that I have offered a threat to that person, and because of which he had been forced to do an act or omit to do an act which was legally bound to do. That is also not made up from the FIR, my lord. This was only made with a purpose to put pressure on that advocate who is the sister of this present petitioner, my lords, so that that case against this present informant, another FIR will not be pursued by the advocate. That was the sole reason, my lord.
Yes, the statement have been recorded.
Lordship, their statement has recorded, and their statement also does not reveal any such.
Yes, no offense is made.
Only 2 pages. May I read the 3 questions? Number? Case number
959.
Okay. Heard Mr. A. Borua, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned additional public prosecutor. On perusal of the office note dated dated 6/3/2026. It appears that the service report in respect of notices issued to respondent number 2 has not been received, though it reflects that the notices were already sent by speed post on 9/1/2026. Stop. In view of the above, the petitioner, the registry is directed to place before this court the postal track consignment report of notice sent to respondent number 2 through speed post on the next date fixed. Let this matter be listed. Ramesh at the date due. Let this matter be listed on 1st of April. 1st of April.
Very well, my lord.
Learned counsel for the petitioner submits that in the instant case, on a bare perusal of the affair, it would reveal that no offense has been made out under any of the provisions, any of the penal provisions under which this for PS case number 959/2025 has been registered. He further submits that the present petitioner, being a student and an aspirant of civil service examination, would be highly prejudiced if the investigation is allowed to be continued. How it will affect you?
My lords, because of this, he will not, while he will be applying for the examinations, my lords, he has to fill up the form where any cases are pending
And
against him, my
therefore,
lords.
disposal of the instant criminal petition is of utmost urgency. Stop. On the other hand, Mr. P.S. Locker submits that the case diary of this for PS case number 959/2025 is all available before this court, and statement which includes the statement of witnesses recorded by the investigating officer. Stop. Considering these submissions as well as submissions made by learned counsel for both sides, as well as materials available on record, it appears that this case needs to be considered on urgent basis. Accordingly, the case diary which is available before this court may be retained till next date, and an effort may be made on the next date to dispose of this case, subject to condition that the notice issued to respondent number 2 is found to be duly served. You choose a date.
My lord, in this month itself, if it's possible,
You choose any date.
on the 16th, my lord.
ऊपर कहीं 1st of April लिखा है ना? Somewhere. Make it 16th of March. Let this matter be listed on 16th of March.
We have also received the board does leadership as 959 and 960 also.
Retain the case diary which were called for earlier. No interim at this stage. On 16th, we will try to dispose it.
And one more thing also, procedure recorded that statement of witnesses has been is available in the CD. Only the complainant statement is available.
He line to cut it. Statement of witnesses available.
Statement of complainant is available.
Otherwise, the FIR does not indicate.
Nothing is there. Even in CD also nothing.
We'll try to dispose it of on next day. 16th of March.
My lord, until
वो काट दीजिए.
Again,
No,
maybe
investigation will otherwise not continue. CDs with the PP.
oblige, my lord.
Item 57.
May I please your lordship? Lordship may peruse the last order dated 31/2026.
Yes.
We are asked to deposit the amount of 20%. We have deposited the amount, my lord.
Okay. Now, any notice has,
My lord, service report is awaited, my lord, as per office note dated 6/3/26.
you have taken steps?
Yes, my lord. There is an interim order is also there.
Heard Mr.
A Gayan.
A. Gayan, learned counsel for the petitioner, who submits that in pursuant to the directions of this court by its order dated 31/2026, the petitioner has deposited an amount of rupees 50,000 before the registry on 9/3/2026. What dates are below the signatures?
My lord, it is a registered have put sign on there.
May authorized
So
signatory.
today I have submitted.
No, what are the numbers which are reflected? You have a copy of this?
No.
Look at this. Whether these are dates or
Today only they have received it.
देखो। What are those figures? Is it date or some other?
Some other authorized sign. 7(3) authorized sign is there.
Below the signatures, some figures are mentioned, na? What are those figures?
Today we have deposited the demand draft, my lord.
No, what are those figures? Whose signatures are those?
This has been, we have submitted before the registry, my lord, they have given us this document.
No. I have marked two signatures. Whose signature?
So signatories from the registry of this court, man.
Okay, then what figures have been, some figure have been mentioned. Is it
Date, man, today's date.
what is the date? Read out the date. If it is date, then it is doubtful.
not, that can go, 19.
Because it is of the year
In the
2000.
lower part, it is 9/3/26, but in the earlier part.
Today we have made the payment, my lord, demand draft is submitted.
Demand draft number niki ekita upor.
Demand draft
Ekita number.
probably, man. Demand draft number, maybe. But they have received it, where we have deposited the demand draft.
क्या लिखा last line? Stop. In support of his submission, learned counsel for the petitioner has submitted a photocopy of letter dated 9/3/2026.
That is the original, man.
This is, oh,
Down part, below part, my lord, you'll find the seal, my lord.
letter photocopy of letter dated 9/3/2026, on which seal of the registry has been put in original. Stop. We can keep it in the record. Let the same be marked as A and kept in the record as a part of it. It also appears from office note that the service report in respect of notice issued to the respondent by speed post has not been received. The registry is directed to place postal track consignment report of the notice issued to respondent number 2 before this court on the next date fixed. No, not respondent number 2, sole respondent. Sole respondent.
Yes.
On next date fix. Let this matter be listed on 20th.
Interim order needs to.
The interim order shall continue till next day.
Item 58.
Next.
20 more. Item 58.
None has appeared for the petitioner on call. Let this matter be listed on 20 March 2023.
Item 59.
Wait, please, your lordship.
Yes.
Lordship.
On 31/2026, this court has passed the interim order.
When have you taken steps
I have taken a step, sir. I have taken steps, but did forgotten. Taken a step
Okay, by speed post,
by speed.
will direct.
Yeah.
Heard Mr. M. Rahman,
Rahman.
learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of office note dated 6/3/2026, it appears that notice issued to respondent number 2 has not yet returned. Stop. The registry is directed to place the postal track consignment report of the notice issued to respondent number 2 by speed post, on the next date fix. Let this matter be listed on 20th of March, 27 March.
Admission item 32.
Yes,
May please your lordship. Your lordship.
yes, let her submit.
May it please your lordship, we have filed Wakalatnama on Saturday. And we need 1 week time for applying the copies.
Lord, your lordship will see the order dated 19/11/2025. It was order session.
Order to actually copies can you go
What is the issue?
Issue was regarding the maintenance, that the order was given from the date of.
Your wife, your husband.
I am the wife, he is the husband. And should be from the date of the application.
Okay.
That is the.
Otherwise, you are getting maintenance.
Yes, that is, it is area maintenance which has to be made. Something around 6 lakhs. And they have taken 3 months' time to pay. The order reflects that also.
But they have now changed the council.
Yes, that is the issue. Again, they will change another.
Well, it is between husband and wife. Can it be amicably settled?
It is a tried best, my lord. It is not settled. Because he is giving the maintenance for the children, not for the wife.
Okay.
It's for the children, my lord.
How old are children?
Now one is in class 12 and another is class 10.
How much you are getting?
Only 15,000, my lord, to 25,000 for both.
This revision is only for the area.
Area, my lord. And
Between-
enhancement for modification also.
Modification, you can approach the trial court.
Yes, that is okay. my lord. So for this area is concerned,
Heard
that is-
Mr. K. Bhattacharjee, the learned counsel for the petitioner. Also heard Miss M.
B. Chakraborty.
What is your name?
My M. Bhuya.
Be louder.
M. Bhuya.
M. Bhuya. Heard Miss M. Bhuya, learned counsel, who submits that you are appearing on behalf of?
B. Chakraborty.
Appearing on behalf of Mr. B. Chakraborty, submits that the respondent has engaged them recently only, and they have filed Wakalatnama. You have already filed
On Saturday.
Wakalatnama on last Saturday, that is on 7th of March 2026 only, and they need at least a week times to go through the brief and apply for certified copies of necessary documents. Considering the submissions made by learned counsel, the prayer is allowed. This is item number.
32.
The name of Mr. Who are the engaged counsel?
Now, new B. Chakraborty.
Not P.K. Majumdar.
No.
Not he.
Name of Mr. B. Chakraborty and Miss R. Bhuya be reflected in the cause list as engaged counsel for the respondent henceforth. Let this matter be listed on 23rd of March.
Still caution.
Item 34.
May I please your lordship?
Yes.
My lord, I am appearing as legal aid counsel. This criminal division petition is filed against the judgment and order passed by learned session judge Gulaghat, my lord. In which case the learned session just dismissed the appeal and set aside, appeal the order of the learned assistant session judge order, my lord. Already in this case, my lord, LCR has been received and my lord, today is fixed for admission hearing.
Will admit. Who is, no, who is on the other side? Only PP or?
Only PP matter, they have not made the party matter to the other. matter.
Convicting.
Informant victim matter.
41, 341, 326 and
307 matter.
7 years punishment, my lord. LCR has been received, my lord.
Is there any interim interlocutory application?
Yes,
That's
my
what I
lord,
want.
that order was rejected.
Oh, that was,
Son of, yes, my.
that was rejected.
Yes, my lord.
Then this appeal need to be heard early.
My lord, yes, my lord. Admitted and only my lord, short date may be fixed, my lord, for hearing.
Yes.
LCR also.
And Miss
received.
PB Bordole, London Legal Aid Council appearing for the revisionist. Also, Mr. B. Sharma, London. Additional public prosecutor appearing for the state respondent. It appears from the office note that the records of the first appellate court as well as the trial court along with case diaries have been received. Stop. Hence, this revision is ready for hearing. When?
My lord, this month.
No, March last year, no.
March last year.
April.
2026 में था ये सब 2026.
April. 28 April.
8 April. 20%.
Election of
28 April.
20. Oh,
Let
highly
this,
obliged.
let this matter be listed for hearing on 28th April.
Item 46.
May I please, your lordship, statutory appeal, my lord, POXO case, section 5 years, 6
Heard
years.
Mr. S. Howard, learned counsel for the appellant. This appeal under section 415 of BNSS 2023 has been preferred
5 years, no?
by the appellant, Shri Kajal Das, against the judgment and order dated 23/12/2025, passed by the Court of Learned Special Judge Lakhimpur, North Lakhimpur in special POXO case number 89/2024, whereby the appellant has been convicted under section 354B of the APC as well as section 10 of the POXO Act and has been sentenced to undergo rigorous imprisonment for 5 years under section 354B of IPC and also sentenced to pay a fine of rupees 3,000 in default to undergo simple imprisonment for 2 months. Stop. The appellant is also sentenced to undergo rigorous by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April. Let the records of trial court as well as first appellate court along with the connected case diaries be called for from the concerned courts. The registry to take steps for requisitioning the aforesaid records. You are in jail.
In jail for the last 621 days. Since the date of lodging FIR.
We are issuing notice.
My lord, my lord.
In IA also issue notice. Same date.
My lord.
47.
May I please the Lordship? Lordship is appealing against the conviction.
Mr. Ihawk, learned counsel for the appellant. Also, Mr. B. Sharma.
Lordship, one.
Yes.
Lordship, in this case, Lordship, I have annexed all the documents and prima facie my case is there. So my Lordship interim prayer may be considered today. Otherwise, Lordship, it is my
No,
right.
my lord, here is the 7 years conviction, my lord. 304 part 2, my lord. A court is required, my lord. It is not yet admitted, my lord. But it is also required, my lord.
But is he is
No, notice has to go.
My lord.
First notice है.
Shiva.
क्या लिखा? This appeal under section 415 within bracket 2 of BNSS has been filed by the appellant Bakkar Ali, impugning the judgment and order dated 4/2/2026, passed by learned Sessions Judge Dhubri, additional Session Judge Dhubri, in Sessions case number 194/2012, whereby the appellant was convicted under section 304 part 2 of Indian Penal Code and was sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of ₹5,000, in default to undergo further rigorous imprisonment for 3 months. The appeal is that I have gone through the grounds of appeal and heard learned counsel for the appellant. The appeal is admitted. Call for the records of the trial court and issue notice to respondent number 2. The appellant shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April. The registry shall take steps for requisitioning the records of the trial court. Let this matter be listed again on 6th of April.
My Lordship.
In IA,
Lordship.
IA issue notice.
My Lordship, my prayer only Lordship. Then on the next day, Lordship, my I may be considered Lordship.
Considered and rejected.
Rejected, my lord.
Lordship, that is-
Only judgment.
What I will do in next date,
My lord.
on the next date,
My lord.
you want me to dictate now.
My
No,
lord.
no, Lordship.
So on the next date, perhaps I may reject your prayer.
My lord.
Lordship,
My lord.
Let me give some indication.
No, Lordship, I am saying, Lordship, my prima facie case is there. My
No,
conviction
on
is
next
not-
date you press, you convince the court on that day.
That day, my lord.